Good morning, members of Joint Judiciary. It's great to see you here on the second day of our last interim meeting on November 12th, starting on time and under budget, sort of, kind of. So committee members, we'll go ahead and get started because we do have a full day, and we discussed yesterday the need to maybe extend that to follow through with our topic of Title 25, which we'll do at the end of our meeting today if time allows. So just a reminder to the public and members of the committee, our meeting might end a little later than we anticipated today as a result of the need to extend that work over to today. But with that, we will start with our normal agenda for the morning, which is our updates from the Wyoming Supreme Court. And we have Miss Elisa Butler here joining us this morning. Welcome back, Miss Butler. It's great to see you. Introduce yourself, of course, back to the committee and share with us any updates.
Good morning. Thank you, Madam Chair, Mr. Co-Chair, members of the committee. My name is Elisa Butler. I am the State Court Administrator at the Wyoming Supreme Court. I know on your agenda today, you also have Chief Justice Fox and Claire Smith. Unfortunately, I am a lone wolf from the Supreme Court today. The Chief Justice sends her regrets. She is actually working with the Judicial Nominating Commission today. And Claire Smith is feeling a little under the weather this morning, so we let her take a sick day. But that we do let people do that every once in a while. So I don't have many updates for you today. I know there are two bill drafts that you all have in front of you. I think that you will discuss as part of this topic this morning. And so I just wanted to make a few quick comments and then kind of hand it over to the people who those bill drafts will affect the most, which is the district court judges and possibly the circuit court judges, if you would like to hear from everyone. And just to give you a few introductions of the people that we have here today, we have Judge Lavery from the 3rd Judicial District. He is a district court judge there. Judge Blumel, who is also a district court judge in the 3rd Judicial District. Judge Rumpke, who is the district court judge in the 6th Judicial District. Judge Hibben, who is a circuit court judge in the 8th Judicial District. And Judge Chambers, who is a circuit court judge in the 1st Judicial District. And behind me to my left, you will see Mona McCauley, who is the clerk of district court from Platte County, and Diane Sanchez, who is the clerk of district court here in Laramie County. So you have a full room of judiciary people here. The bill drafts that you have in front of you or that you will be discussing today really are centered around the idea that you heard at the last session, which is we really need to work to retain the qualified judges we have on the bench right now, and also to recruit qualified judges for the future. And those two bill drafts are really aimed at that purpose. And so what you'll be looking at today or discussing are a new judge bill for 3 new judges in the 3rd Judicial District, the 7th Judicial District, and the 6th Judicial District, and then also a housing allowance bill that mirrors what the executive branch does for its employees for judges. And I don't know if there are any questions about that, but I do want to be mindful of your time because I know you have a full day today, and I would like to give the judges an opportunity to speak because I think they will have better information than I. But I would be happy to stand for any questions if there are any.
Thank you, Ms. Butler. Are there any questions for Ms. Butler? I think with that, what we will do is quickly flip to Mr. Fuller and have him explain to us both bills. And I think we'll just address both bills together. I think they're simple in what they accomplish, and there's not a lot of actual work to do on those bills. So policy decisions just to be made for the body. And so for expediency of time, allowing all of the stakeholders to comment on both bills simultaneously, I think will be effective. So Mr. Fuller, if you just kind of remind us where we are with both bills and what both bills do.
Yes, Madam Chairman, members of the committee, the first bill 22 LSO 238, and it should be working draft 0.5. This was included in the packet that was at your seats yesterday. So it is a different version than what was included in the packets that we mailed out to the committee. This first draft does 2 things primarily. It authorizes and funds the district judge positions or the additional district judge positions in the 3rd and 7th district and then includes the authorization language for the 6th judicial district to begin that process of an additional district judge. And it would require the certification of suitable facilities, delivery, and then the subsequent legislation. So just running through this bill draft quickly, page 2 amends 53102 to just specify that there would be 4 judges, 4 district judges in the 3rd and 7th judicial districts. So that is a change in statute. The staff comment on page 3 is just a note for the committee that the committee did sponsor a bill draft at the last meeting that set the kind of the first stage for all 3 districts, so that if the committee, how the committee addresses that bill draft may need to be amended depending on this bill draft. Page 3, beginning with line 15, this section is the appropriation for the additional judge for the 3rd judicial district. The monetary figure came from the Supreme Court and is for the next fiscal biennium. And then on page 4 is the authorization for 4 full-time equivalent positions, one of which is the district judge, him or herself. And then page 4, line 10 is a requirement for suitable facilities for the additional district judge must be available in the 3rd judicial district. Page 4, line 17 is the exact same language except for the 7th judicial district additional judge, the same monetary figure, the same authorization for 4 positions, and then the same requirement for additional suitable facilities for that additional judge. Page 6 is the section that authorizes a 6th judicial district an additional district judge upon completion of a certification from the Chief Justice, delivery of that to this committee and Joint Appropriations Committee, and then the enactment of subsequent legislation. And then this would take effect July 1st, 2022. And then unless there are questions, Madam Chairman, I'll proceed to 22 LSO 266. This draft is 0.3. What this bill draft would do is authorize the award of housing assistance to judges and justices pursuant to rules that are adopted by the Supreme Court. Because of the lateness of this request, this bill draft did not go through our normal kind of LSO review process. So it's possible that we may identify further technical changes should the committee sponsor this bill. On page 2, this just creates a new section in the judiciary statutes and just provides that subject to constitutional and statutory provisions concerning when salaries become effective, justices and judges of the district court, chancery court, and circuit court may receive housing assistance if the judge or justice resides in a county in Wyoming where the average cost of housing is significantly higher than the statewide population weighted average cost of housing. And then the Supreme Court is required to promulgate rules for the award of housing assistance under this section. The staff comment on page 2 just notes that the committee may wish to consider specifying some minimum percentage that must be met before this housing assistance is awarded. And that's just really getting, I think, at the word what the word significantly means on page 2, line 10, whether the committee wishes to further define what exactly that means. In addition, Madam Chairman, I would just note 2 constitutional provisions that the committee may wish to be aware of. You have information to this effect that was included with this bill draft. The first is Article 5, Section 17, which concerns the salaries of judges of Supreme and District Courts. And all this provision says is that they shall receive such compensation for their services as may be prescribed by law. That compensation shall not be increased or diminished during the term for which a judge shall have been elected, except when a new term or there's a new appointment, any change would become effective for each of those judges at that particular level. I think that provision is relevant here insofar as if this housing assistance is deemed compensation, as that term is used in the provision, its effective date may have to wait until there's a change in a particular position. Then next is Article 3, Section 27, which just provides that the legislature shall not pass local or special laws in creating, increasing, or decreasing fees, percentages, or allowances of public officers. And here, I think the question for the committee would be whether a judge is or is not a public officer for purposes of that provision, given that the bill seems to contemplate that some judges may receive the housing assistance, others may not. I would note that the court in at least one other provision in Article 3 has stated that judges are not public officers. And I believe that's Article 3, Section 32, which concerns, I think, the compensation for public officers. With that, Madam Chairman, I would stand for questions.
Thank you, Mr. Fuller. We do have a question from the co-chair, Co-Chairman Olson.
Thank you, Madam Co-Chairman. Mr. Fuller, on the effective date in the Article 5 analysis, would we need to change the effective date? Because the statute, as I read it, is permissible.
Yeah, Madam Chairman, Chairman Olson, I think that's why the language on lines of the bill draft, lines 5 and 7, subject to that provision. And I think the real effect here would be to leave it to the court to determine, well, I think the legislature would determine in the first instance by the inclusion or exclusion of that language, whether housing assistance is compensation for purposes of Article 5, Section 17. But that would, and I'm not sure if I'm fully answering your question.
Well, Mr. Fuller, I think I agree. I definitely agree with you on the analysis of Article 5 applying, if it is deemed compensation, it would have to only apply to a new appointment. I think that makes sense. But in terms of the bill, we wouldn't have to change the effective date because, and maybe I just misunderstood you.
Oh, Mr. Chairman, if you mean just the July 1st, 2022, I do not think you would need to because of that language on lines 5 through 7 of the bill draft.
I got you. Okay.
Further questions for Mr. Fuller from the committee? Representative Yan?
Thank you, Madam Chair. Mr. Fuller, do you know of any housing or cost of living indexes that we use in other parts of statute for consideration with the staff comment on that bill?
Mr. Fuller,
Madam Chairman, Representative Yen, not off the top of my head, I do know the Department of Administration and Information has a housing index that they use for purposes of executive branch employees and receiving a housing allowance.
Thank you, Mr. Fuller. And I'm just going to add some additional background for the committee on this. Yeah, this bill is intended to be consistent with how A&I operates with other state employees who are located throughout the state and need housing allowances associated with where they may live. And so the bill is consistent with that as a result of kind of the challenges that the judicial branch has experienced as a result of those locations that do experience significant housing challenges. And so this bill is just intended to be consistent with other state employees as applied to the judicial branch. So that's really its purpose and intent. And a further explanation too on the district court judge positions, authorization and funding, why this bill is again in front of you, committee members. As you recall, we did unanimously vote for the creation of 3 new judicial positions across the state in the 3rd, 6th, and 7th judicial districts. The 3rd judicial district being Uinta and Lincoln counties and Sweetwater, and the 6th being Campbell, Weston, and Crook, and 7th being Natrona. It came to our attention, and there's this 2-step process associated with the creation of a new judge in a position. One is the statutory authorization to add an additional judge to a location. And then 2, a certification from the Supreme Court, as you see in that bill draft, that the judicial district actually has the physical capacity for bringing in a new judge. So can the courthouse actually accommodate that new judge? That process has already taken place in both the 3rd and the 7th judicial district. So this bill draft is intending to kind of expedite that second step of the process in that the Supreme Court has already certified that both the 3rd and the 7th judicial districts have that space for the addition of a new judge if the legislature moves forward with this action. The 6th, that has not happened for the 6th judicial district for Gillette. And so that traditional 2-step process still needs to take place. So we would pass the statute for the creation of a new judge up in Gillette, and then the Supreme Court would walk through certifying that Campbell County actually has the physical accommodations for the creation of a new judge. So I hope that provides some additional kind of clarity as to how these bills came to be and why their place in front of you this morning. So further questions about these 2 bills to Mr. Fuller or Ms. Butler as she's in front of us? Representative Washut.
Thank you, Madam Chair, Co-Chair. Ms. Butler, the most recent appointment of a district court judge, how many applicants did we get for that position?
Madam Chair, Representative Washit. So as I said, the Chief Justice is right now working with the Judicial Nominating Commission, I believe, in Teton County for that vacancy that will come open in January. And I believe there were 7 applicants for that position, which is pretty low.
Thank you. If we approve 3 new judge positions simultaneously, what is the prospect for quality applicants for that many vacancies simultaneously?
Or if you know.
Madam Chair, Representative Washit, I don't know. It varies across the state, to be completely honest with you, as to how many applicants we get in certain locations. I think there's a good opportunity and we're trying to get people to apply. So.
Co-Chairman Olson?
Yeah, thank you, Madam Co-Chairman. And just for the committee's edification, if I'm understanding Representative Washit, your question right, and Ms. Butler, you could confirm this, but the district judges have to reside within their district. So that's my understanding statutorily. And so by opening up 3 different positions in 3 different districts, geographically, they're different locations. So they wouldn't be the same, they couldn't be the same applicants theoretically, at least. They could move, I suppose, but you have to reside in the district to have the appointment. At least. Yeah, I suppose that is true.
Willing to move.
Willing to-
Willing to move, Ms. Butler, is that correct?
Madam Chair, Mr. Co-Chair, that is correct. So, and that happens quite frequently. We just had a judge who took the bench in Fremont County in Lander, and he was from Gillette. He worked in Gillette, so he moved to Lander to take that circuit court judge position.
Further questions? Senator Cooper.
Thank you, Madam Chair. Ms. Butler, is there in District 6, is there any restriction that we keep talking about Campbell, but is there any reason this couldn't be housed in Crook or elsewhere?
Ms. Butler, I do believe that judicial district encompasses Campbell, Crook, and Weston counties.
Madam Chair, Senator Cooper, that is correct. It encompasses that entire county. And I believe, and I'd have to go back and look at the statute, but I believe where the judge resides is in statute. Maybe the Supreme Court provides that location. I don't know off the top of my head. I would let you know that Judge Rumke is here, who is from the 6th Judicial District, and he probably has much more information with regard to that question than I do.
Mr. Fuller?
Yeah, Madam Chairman, Senator Cooper, the statute doesn't specify for each district, where judges, should or should not live. So currently under statute for the 6th Judicial District, it's silent as to the residency of those judges, other than they have to reside in that district. It's the 2nd Judicial District that spells out that 1 judge in Albany, 1 in Carbon. In the 3rd, 2 must reside in Sweetwater, but silent on the 3rd. And the 4th, 1 in Sheridan, 1 in Johnson. And the 9th, 1 in Fremont, 1 in Teton, and 1 in Sublette. And that's what's spelled out in statute, Madam Chairman.
Thank you, Mr. Fuller. Further questions? And I also want to distinguish, I think the differences of what we're talking about is where a judge lives personally, where his home is located or her home is located, as opposed to where the courthouse is located. So make sure if you have questions about that, distinguish maybe where the courtroom is located as opposed to where the judge resides for a home. Senator Cooper?
Madam Chair, yes, that's what I was referring to. We have the Campbell County Courthouse. We also have a Crook County Courthouse and a Weston County Courthouse. And I don't see why that judge, I just wondering if the citizens for the east part of the district might be better served with the judge in that direction.
Thank you. Further questions from the committee? And then we'll invite all of the district court judges, please come forward. Welcome. It's good to see you again this morning. Welcome, Judge Rumke. Come Good morning. Please introduce yourselves again for the committee, if you may, with your names and your judicial districts. That'd be most helpful, and we would be grateful to hear your comments this morning.
So I'm Rick Lavery from Green River, Wyoming, 3rd Judicial District, Sweetwater County.
I'm Joe Blumel, 3rd Judicial District. I'm in Kemmer in Lincoln County.
Well, welcome this morning. We would love to hear your comments. Again, I think we heard from you at our last meeting, or some of you, about the need for these judges. Any questions that you can provide, or answers you can provide to the questions you've heard this morning, or further comments you'd like to make on these bills?
I would, Madam Chairman, members of the committee, I would speak first to the bill involving the housing allowance. I learned about this on Wednesday morning and have been kind of getting additional information in the last couple of days. And my understanding is the housing allowance metric that's going to be used is the same one that's used for the executive branch. And really, the most dire need is in Teton County. I mean, I don't think that housing allowances really are activated in any other part of the state at this time, but there are some that are close. And I also learned that all of the staffs in Teton County, both circuit and district court staffs, get the allowance. It's just the judge that doesn't get the allowance. And the hope is that it would attract additional applicants. Now, the application process for Teton County is happening today, so or the interview process. So I don't know that it would affect us right now, but as far as the conference goes, I think the conference is supportive of the allowance, but it won't have a big impact on most of us.
Judge Rumpke, would you like to speak to your service to us up in Campbell County, connecting to Senator Cooper's concern about how the 6th Judicial District judges serve Weston and Crook counties?
Thank you, Madam Chairman. Senator Cooper, that district is, all of our districts are unique, but the 6th is somewhat unique. We have a very big county as far as the volume that we work there, and that is Gillette. And then Crook and Weston counties have a much smaller volume on the scale of around 10 to 12% each. So about 78%, I think that's right, of our work is in Campbell, and 10 or 12%. There are facilities there, and we would love to get our 4th judge sooner rather than later, but we share the Crook and Weston facilities with the circuit courts. So we wouldn't have a dedicated chambers and courtroom. That judge would use it part of the time.
Thank you, madam. Thank you, Judge. I just was thinking about how well it works in the 3rd district. Similar circumstances where we're spread over quite a distance, and the judge in Uinta does an excellent job of taking care of the people in the western part of the district, while the other judges and the judge we're going to add, and probably split about similar to what you are, about a 1/4 of the work in the eastern part, or in their case, it's in the west. I thought it was a similar situation. It might be something worth considering, especially if you're short on space. Thank you.
Further questions from the committee? Need some more coffee? Judges, Representative Washington?
Thank you, Madam Chair. This is probably pertinent to both bills, but in terms of the selection process, can an applicant be considered for 2 different district court positions simultaneously in the judicial nominating process?
Judges, if you know.
I don't think there's any reason that they couldn't, and I think it's happened when there have been application processes that were relatively close. I know that the nominating commission has tried to spread them out a little bit because of the workload that the commission has, and most recently, you've all probably noticed how many judges have and being appointed, and that commission is made up of volunteers. And so they're working pretty hard right now. And so how the chief will choose to roll these out when the legislation is passed, it will be interesting to see. I think she's going to have to give that some thought, because they're not going to be able to be in two places at once. But I don't think there's any reason why you couldn't apply for two positions or all three. You can come from anywhere in the state. You just have to move if you happen to get the job.
All right. Well, thank you so much this morning, Representative Yen.
Thank you, Madam Chair. So regarding the staff comment again on the housing allowance bill, do you think it makes sense for us to put in statute some sort of indexing and threshold, or would you guys just promulgate in rules to have it be the same as the state employees?
Judges, if you know, Ms. Butler? It's my understanding what Mr. Co-Chair and I have been told is that it is to be consistent with how the executive branch operates, using the exact same metrics as A&I applies to the need for cost of living for other state employees in other areas of the state. So nothing unique here. And I don't think that the Appropriations Committee would allow anything but that. Yes, Judge.
Madam Chair, Representative Yin, one of the things in my mind that I think is important to consider is I can actually recall back when I think this housing allowance was implemented. I think it was actually implemented because of Campbell County, when there was a boom going on in Campbell County and housing was at such a premium up there. And so it's moved around some of these other locations in the state. Although right now the driver clearly is Teton County.
One additional question, Madam Chair. So do you think that one of the reasons that we only have 7 applicants for the Teton County position is because of housing issues in Teton County?
Judge?
Madam Chair, Representative Yin, I would be remiss if I said otherwise. I think it's almost prohibitive for somebody. I would not be able to relocate, and I don't know that I could afford to rent, let alone buy housing in Teton County on my salary if I didn't have other income that would allow for that. That's me personally. I can't speak for the conference.
Yes.
Madam Chair and Representative Yin, I do know from talking to the chief that all of the applicants are from Teton County. So no one outside of Teton County applied for the position. And it makes sense as Judge Blumel said, who can afford to live there unless you already do. And so that's what's happening. But applicants are down all around. The Campbell County application pool was down. I think that, and it was in the range of 7. And I think that was also true. And where else do we have? The Circuit Court in Lander. And it's for different reasons all around. You know, I think it's cost of living, it's pay, it's the kind of work. I think Judge Wilkie told you in September, a lot of people don't want this job. And that's sad, but there is some truth to that.
Representative Oakley.
Thank you, Madam Chair. Judge Lavery or Blumel or Rumkey, I guess anyone, I've heard a couple of times about Lander specifically, which I'm aware of. Do you know the applicants that applied to the Lander? I mean, I guess my thought here is a little pushback on the number of applicants equates to the quality of the candidates, that somehow I'm hearing that we're not getting quality Wyoming lawyers applying for judgeships, and wondering if you have any comment on the quality of the candidates that are applying for these positions.
Madam Chair,
If you-
Representative
You
Oakley.
dare wish.
So who applies is not something that we know. Those names are confidential except for the three. But in talking with Chief Justice Fox, I think she is feeling that the applicants are quality people. It's just a fewer number, tending to be primarily people from the public sector, prosecutors and public defenders, or people that are working in state government, not private attorneys. So that's really the only demographic that I'm aware of.
Judge?
Madam Chair, Representative Oakley, again, this is just my personal opinion, and that and maybe 5 cents would get you a piece of candy somewhere. I guess probably 25 cents these days. I think it's, I was a private attorney when I applied for the bench. I think that the reality that you have when you look at it, and I'm not saying that you don't have private lawyers that will continue to apply for these positions, but I think the competitive realm that there is the income that a private lawyer can make in Wyoming is, it was a cut in pay for me to come into this position. I made it very consciously, and I chose it, and I think that that still happens. And so I think one of those factors is for you all to decide, and the legislature to decide how that is. I don't have statistics on it, but I can just speak personally, and I don't know if that's responsive to your inquiry, Representative.
All right, further questions of the judges? All right, seeing none. Senator Cole?
Thank you, Madam Co-Chair. Yeah, just a general question on the housing allowance assistance for the judges. Does anyone have an estimate of what that really accounts to for costs projected? Because in this case, we hear Teton is the real issue. Can someone maybe expound on that? Thank you, Madam Co-Chair.
Judge Lavery?
Senator Kolb, Madam Co-Chair, the numbers that I've seen is that it amounts to somewhere in the vicinity of $1,600 a month in Teton County.
Any follow-up, Senator? All right. With that,
Sure.
okay. All right. Thank you, judges. I appreciate your time this morning.
Thank you for allowing us to be here these last 2 days after watching yesterday. I know you're going to have a long day today, so I hope we made your time shorter this morning.
Thank you so much. Appreciate you being here and appreciate all you do for Wyoming. Any further public comment on this bill? We have Circuit Court Judge here with us this morning. Circuit Court Judges, any comments? Welcome. Welcome to the Joint Judiciary Committee. It's great to see you. If you would introduce yourselves to the committee and what judicial district you reside.
Morning, Chairman Nethercott, Chairman Olson. Good morning, committee. I think I'm good. Sean Chambers, I'm Circuit Court Judge here in the First Judicial District, and sitting next to me is.
Good morning. My name is Nate Hibben. I'm from Torrington in the 8th Judicial District.
Thank you for having us here this morning. I don't really have any prepared remarks or specific comments about the things you've heard. I could tell you that Circuit Court Conference is supportive of the housing allowance bill. I don't think the expansion of the 3rd, 6th, and 7th affects Circuit Court Conference at all. Certainly, those are the comments I have. Do you have anything, Judge Hibben?
Judge Chambers, no, I don't have anything much to add other than the conference, I think, is broadly supportive of anything we can do to make sure that the position remains an attractive position and that we're getting good applicants.
Thank you, judges. Representative Monitor.
Thanks, Madam Chairman. Do you know how many Circuit Court judges are in Teton County? There's just one.
Further questions for the Circuit Court judges? It is great to see you this morning. We thank you for taking the time. Judge Chambers, I know you've been with us yesterday and today as well. Thank you for taking that time with us.
Thank you.
All right, District Court Clerks, would you like to comment on this bill? No? Great. All right, any further public comment? All right, seeing none, public comment is closed. Committee, back to you. We'll start with the, I'm gonna pull my numbers up here. 22 LSO 238, working draft .5. District Court Judge Positions Authorization and Funding. Is there a motion on the bill?
So moved, Madam Chairman.
Moved by Representative Swanitzer. Is there a second? Seconded by Senator Cost. Discussion on the bill?
Madam Chairman, I guess I do have some concerns and issues. This committee did vote generally for the motion for another bill to move forward to session already. I don't know what the process is. I don't believe both bills, if this moves forward, are there. And so as part of this motion, if this bill were to move forward, would we repeal our previous motion and have to take a voice vote on that? I just don't understand the process of how the best way, assuming we want this bill, because conceptually we all generally voted for it, and you put the appropriation on it, and I know that might give people pause, but maybe some explanation from LSO on the best process.
Yeah, great catch, Representative Swanitzer. You're absolutely right. That staff comment there hits the nail on the head. Mr. Fuller, can you give us some guidance on how to deal with that?
Yep, Madam Chairman, at this point, probably the best way to deal with that bill draft would be to address it in session or perhaps not address it in session. To reconsider that today, that would not be possible because under the committee rules, there has to be a 15-day notice of a reconsideration of a bill from a prior meeting. So without that notice, I don't think that bill could be addressed today.
Yeah, so committee members, what I envision is, when session starts here in February, either House or Senate committees can get the previous bill draft, and then just amend it to remove the provisions associated with the 3rd and the 7th judicial districts, leaving just the 6th. And I don't think that would be difficult to do, and quite an easy lift for us to manage in session for either committees to handle and work through. Is that process clear? Yeah, Representative Crago.
Madam Chair, so just so I'm clear, I guess I was under the understanding that as we look at 238 sitting here, it covers all of the issues, that we wouldn't have to go back and look at 117 was our previous draft. We would just could draw 117 or.
We could draw it, Representative Crago. Would you like us to draw it?
Would, thank
We
you.
will draw it. Or we can amend it and repeal it. So it's important to recognize we will move one of these bills out. It'll go to the Appropriations Committee. Again, the Appropriations Committee will present that bill probably. And so there's some committee maneuverings to happen when the budget session starts in February. We'll draw the bill. Representative Swanitzer, do you feel better about that process?
Actually, no, Madam Chairman, I feel worse. So this bill, if you look, is only relating to the 3rd and 7th judicial districts and a 4-person appropriation, which doesn't cleanly overlap drawing the other bill that anticipated 3 judges with 3 clerks. And so the appropriation isn't correct, nor is the number of new positions. And so I don't think this is a clean drop and drawing the other bill.
Representative Swanitzer, what bill draft are you looking at? And what bill draft is everyone looking at?
I'm currently looking at 238, Madam Chairman.
Version
calling
5?
For the version. There's apparently a version 5, Madam Chairman. I will review that now.
We'll just take a minute and Representative Swanitzer is a chairman as well and has served in the legislature for quite a period of time. So take a minute. Further discussion on this bill as we work through kind of the procedures associated with the 2 bill drafts to be handled in session. Any further comments or Representative Washit?
Just like to see what the committee's feeling is, whether or not we should specify staggered implementation. If we staggered the implementation of the 3 judges, it would give certainty to each of the districts that they would be getting a new judge should the bill pass. But if 1 or 2 of those judgeships became effective in the 2nd year of the biennium, it would reduce the fiscal cost by half for that first biennium. for those two judges. And it would also give the Judicial Nominating Commission the leeway to get one judge, the most critical, filled first, and then fill the next two in the following year of the biennium.
Good thoughts, Representative Washit, further discussion on that topic? Concern of about too big of an appropriation for one bill from Representative Washit, although the state is flush with cash right now, right? Further discussions from the committee on that? Seeing none? I'm letting Representative Wanitzer get through that bill. I have done the same concern, Representative Wanitzer, to Mr. Fuller about 8 times in an email. We have to be looking at the wrong version. Mr. Fuller is very familiar with this issue.
So, Madam Co-Chairman, Representatives Wanitzer, basically what it came down to is we authorized in the original bill these 3. And then one hasn't gone through that full process. So we could have had 2 different bills, one that takes us to the next level on the other 2 districts where we're already moving into the funding portion because the location's already been decided, it's gone through their county commissioners, et cetera. Or we could fold it all into one bill. And that's why you ended up with a version 5, is to have one bill instead of 2.
Representative Craigo?
And thank you, Madam Chair. Just to, I guess, address Representative Washit's concern a little bit, I think, is this bill only provides appropriation for 2 out of the 3 judgeships for the time being. And so we would not be appointing a judge for the 3rd, which would be the 6th judicial district, until there's actually an appropriation. At that point, they would begin the process, which we don't know how long that will take to get certification back from the district to the Supreme Court. It could be a couple years down the road. And so probably would not, the next budget, be worrying about all 3, but probably 2. And also I would assume, I think the district court judges, talked about this a little bit. The chief is probably going to stagger those anyways because of the workload. She probably won't be able to do them all at once. And so the same people could apply for both positions.
All right, further discussion or questions from the committee? Out on Zoom, everyone feels comfortable with what you're voting on? All right. With that, committee, is there a question? Sensing you're ready for a vote on the bill. Roll call vote. Mr. Fuller.
Senator Cooper. Senator French.
No.
Senator Cole.
Aye.
Senator Cost.
Aye.
Representative Craigo.
Aye.
Representative Larson.
Aye.
Representative Oakley.
Aye.
Representative Provenza.
Aye.
Representative Washit.
Aye.
Representative Rodriguez Williams.
Aye.
Representative Yin.
Aye.
Representative Zwanitzer. Chairman Nethercott.
Aye.
Co-Chairman Olson.
Aye.
That passes.
Thank you. All right, committee. With that, we will move to the housing allowance bill, which is 22 LSO 266, working draft point 3. Is there a motion on this bill draft? Representative Zwanitzer?
Madam Chairman, I would move 22 also 266 version 3.
Is there seconded by Senator Cost? Discussion on the bill. Representative Washit.
Thank you, Madam Chair. I'm not opposed to the idea, but it sounds like from the discussion we had earlier about when this would actually go into effect, if we're presently selecting a new judge for that district, how soon will anyone actually benefit from this bill being passed? It sounds like it could be years down the road.
Co-Chairman Olson?
Well, maybe. I think, Madam Co-Chairman, ultimately, that does depend on the outcome of whether it is considered compensation or not within the lines of the Constitution. That question being undetermined, arguably the statute could apply to the appointment if it's not deemed compensation and it's deemed something else. If it is deemed compensation, then I think you're accurate. It's not going to apply to the current appointment, and those appointments could last years.
Representative Craigo.
Thank you, Madam Chair. My question is, or I guess my thought is actually, it would, when they stand for retention, whenever that is, that begins a new term. And so the Constitution talks about the term. It doesn't talk about the appointment. And so whenever they stand for their first retention, then it could kick in at that point. I don't know, I can't remember for the first time for district court judges how long that is, I guess what the term is. I know the standard term is that, but is it the same every time? I don't know. It seems like some different number in there, but.
Judge Blumel.
Madam Chair and representatives, I believe Representative Craigo is right on target. So I have not looked at the statutes, but the new district judge that will be selected and appointed by the governor may have to stand for retention at the general election in November. And it will depend upon a statutory date as to when and it's an elected official deadline, whatever that is. And then that would be the first retention or the soonest retention. And if they are appointed after that deadline date, then it would actually be the next general election for the United States Congress. And then district court judges are a 6-year term. Circuit court are 4, same thing, but with 4-year term instead of 6-year term. Does that answer the committee's questions, Madam Chair?
Yeah, thank you, Judge Blumel. Very helpful. Maybe stay close, just in case. Might be easier for you. Representative Zwaniter?
No, thanks just for the committee's information, right? So how we do this for state employees and especially for teachers, because we do this for our teachers on school districts in the model. When the Wyoming Cost of Living Index comes out yearly, they recalculate that. So, and in my mind, a judge would just say, hey, my county property tax bill, this is a new yearly, and this is finally putting me above where I can afford to live up here. And that would be when the rules and regs come into effect. I actually don't think when I went to the statutes, they even need this statute to do, a housing allowance. I think they're doing this primarily because when you go to appropriations, you can say, hey, now we're following the law. We need to have a legitimate reason why, well, they don't have a lot of money right now in the courts either. So this idea, I think, came out of a conversation after the last judicial meeting between 3 or 4 of us with some of the judges and the issues that were appearing. And so it came late to this committee because of, do we need a statute or not? Can they just do this internally? Better safe than sorry. But I certainly believe we can trust the judicial branch to follow the statutes and the constitutional provisions there on lines 5 and 6. You can't trust them to do that. I'm not sure how our system of government continues. So I'm pretty confident they're going to make it work within the parameters of the law. And if they don't, I don't quite exactly know how we litigate that to them for their decisions. So strong support of the bill.
Thank you, Representative. Representative Washit.
Question for my fellow representative from this county. Do the teachers use the educational or the housing allowance as a salary? Is it deemed a salary for them?
Representative Zwaniter?
I am unsure, Madam Chairman. I don't believe it's counted as salary. It's counted as an additional subsect. This was a bill we did, I don't know, 6 or 7 years ago. But I remember we were cautious about making it salary. It was an additional per diem addendum, something similar to what, we consider a per diem that we could increase our per diem during a legislative session. as long as we don't consider it a salary bonus.
I think it's important, I mean, from my perspective, that we don't get too caught up on that piece. Primarily because there's a variety of ways to define compensation. And, you know, I'm not qualified to give tax advice, but there is a definition of compensation for, you know, the IRS tax code, as opposed to what we statutorily might deem compensation. So there's different ways of interpreting how that particular housing allowance may be accounted for. And I don't know that that is our primary concern right now. Again, as Representative Zwanitzer indicated, I do trust the judicial branch to follow the law and adhere to those standards. So, you know, good conversation for us to have. I'm just not sure that it is a primary concern of ours at this point. And the need, I think, oh, is this needed now? I think the reality is, as Representative Zwanitzer indicated, that the urgency of the need became critically apparent now as a result of the opening in Teton County for the judicial appointment. I think we heard testimony again this morning that Teton County has not historically been the motivating factor for this, surprisingly, and other areas in our state have been. And not knowing what the future looks like, and I think all the state is suffering from an affordable housing challenge, that it could be another location in the state. It might be Lincoln County, which is experiencing significant growth, as we know from the census. We just don't know what that future looks like when there might be another boom. And so I do think we just resolve this issue for them now instead of waiting for it to be an acute issue then sometime down the road, and be proactive about this piece. Further discussion, Senator Cooper.
Thank you, Madam Chair. Have we addressed the question of the public officer and are these judges considered public officers? As a county judge, they were not, but how does that apply today? Can somebody answer that for me, please?
Mr. Fuller, if you can provide that constitutional provision associated with the definition of a public officer, that'd be most helpful.
Yeah, Madam Chairman, Senator Cooper, as far as my brief research revealed, I didn't find any case interpreting whether a judge was a public officer for the Article 3, Section 27. For another provision that concerns salaries of public officers, Article 3, Section 32, the court held that the judges were not. You know, as to this provision, you know, that's just simply a note for the committee to have kind of, you know, that knowledge just as it considers a bill.
To the lawyers on the committee, would you like to provide any kind of guidance or recognizing that concern about the court's previous interpretation about the definition of a public officer as applied in a different context? It's my thought that perhaps it would apply similarly as they have interpreted before. Representative Craigo?
Well, I thought we could ask for an advisory opinion in the back row.
Circuit Court judges, you are not conflicted on this particular piece. I think it's a safe space, Senator Cooper. That's my thought on it. I certainly would not want us to be passing or voting on a bill that I thought would be unconstitutional. And I don't think our LSO would be advising us otherwise, but just to keep us informed and knowledgeable as we work these issues. Representative Washit?
I guess I'm a little conflicted now as I think about it, that all of our applicants for the vacancy in Teton County where this would apply, at least at this time, already reside in Teton County. So presumably they already are able to pay for their housing presently. So it raises the question, how necessary is this additional allocation of funds?
Representative Craigo?
Thank you, Madam Chair. I guess what I would say is the applicants that live in Teton County are probably giving up a salary that's much higher than what they're going to have once they're appointed to be a judge. It will be a dramatic pay decrease, not increase. And so, yes, can they afford to live in Teton County on their current salary? Sure, but that may not be true when they get appointed to the bench.
You know, in response to that, we are prohibited from making special legislation, right? And so in reverse, the argument that Representative Washington is posturing is that, well, we shouldn't pass this legislation now because it wouldn't affect them now, which is in effect probably special legislation. So I would argue that it's more appropriate for us to apply it now because it actually doesn't affect anyone particularly on the ground, making it non-special legislation more than otherwise, if that makes sense. And again, I don't know that we should use the current circumstances on the ground to justify whether or not judges should have a housing allowance. I think we should look long-term and recognize the utility of this concept for 5, 10, 20, 50 years down the road. Further comments from the committee? Out on Zoom? Question being called, roll call vote.
Senator Cooper. Senator French,
No.
Senator Cole,
No.
Senator Cost,
Aye.
Representative Crago, Representative Larson,
No.
Representative Oakley,
No.
Representative Provenza,
Aye.
Representative Washit,
No.
Representative Rodriguez Williams,
No.
Representative Yin,
Aye.
Representative Zwanitzer, Chairman Nethercott,
Aye.
Co-Chairman Olson,
Yep, the motion carries, Madam Chairman.
Thank you. Would you provide the vote count if you can?
Yes, it is 8-6. Overall, 5-4 House, 3-2 Senate.
Thank you, Mr. Fuller. All right, with that committee, do you need a break or do you want to keep trucking? All right, with that, we will move to contracts in restraint of trade. Do we have Representative Stiff with us?
yes, I'm promoting him to a panelist right now, so he should be able to start his camera and unmute himself.
Wonderful. Representative Stiff, you know what to do. The committee, we will start with working draft 22 LSO 118, working draft 6, contracts in restraint of trade. Mr. Fuller, would you walk us through this bill briefly?
Yep, Madam Chairman, committee members, 22 LSO 118, this is a draft that the committee looked at from the last meeting. And the only change in the bill draft was on page 7 to change that exception for a contract provision regarding the actual cost of a hiring bonus if the employee separates within 3 years of initial hiring. The version from the last draft was 2 years. Generally speaking, though, this bill draft would provide that certain contractual provisions that restrain trade, generally agreements not to compete and employment, are void with exceptions. There are definitions on page 2. The staff comment, which is a carryover from the previous version of the bill, is just a note to consider whether the definition of business entity is necessary, or put another way, whether other forms of businesses should be included in this. So a business entity is only a partnership or an LLP or an LP or a corporation or LLC or a series LLC. So for example, a sole proprietorship would not be included in that definition of business entity. Definitions continue on pages 2 and 3. The staff comment on page 4 for the definition of substantially all is a carryover from the last version. Representative Stith, I believe at the last meeting, noted a proposed amendment to that definition to add after 80% on page 4, line 10, to also include language of a business entity's assets, excluding cash or cash equivalents. On page 5 is the heart of the bill. This is the language that makes void any provision in any contract by which a person is restrained from engaging in a lawful profession, trade, or business, except as otherwise provided in this section. The exceptions begin on page 5, line 30, and the The voiding language in this section would not apply to any provision in a contract where a person is selling the goodwill of a business entity or is selling or otherwise disposing all of the person's ownership interest in that business. Page 6, line 5, the voiding would not apply to any contract provision that prohibits an employee from misappropriating trade secrets or other proprietary business information. Page 6, line 10, any contract provision that requires an employee to reimburse an employer for actual expenses paid for specialized training if the employee separates from the employer and works for a competitor within 2 years of the receipt of that specialized training. And then page 7, line 4, any provision that would require repayment of a hiring bonus if the employee separates within 3 years of initial hiring. The staff comment there is also a carryover just for the committee to consider whether some limit should be placed on that hiring bonus. For example, one that's given due to the employee bringing a specialized skill to that particular form of employment. Then on page 7, line 20, this is just language that would allow any member of a partnership in anticipation of the dissolution or disassociation of that member to agree not to carry on a similar business within a specified geographic area where the partnership's business has been transacted. And then page 8, line 2 is the same concept for LLCs. Page 8, line 17 provides that any owner of a business entity that sells the business entity may agree to refrain from carrying on a similar business within a specified geographic area where the business is sold and where business has been transacted in the past. Page 9, line 17, the act would apply only to contracts that are entered into on or after July 1st, 2022, which is the effective date of the bill. With that, I'll stand for questions.
Thank you. Thank you, Mr. Fuller. Questions for Mr. Fuller? All right, Mr. Fuller, I'm going to have you also walk through the next bill draft so the committee can compare and consider both of them and then ask questions of the stakeholders in relationship to the two that are before the committee. That makes sense for the committee.
Okay. Yep. So 22 LSO 178 should be draft 0.6. This is a bill draft that the committee requested at the September meeting. It is based on, in large part, on Colorado law concerning agreements not to compete. And that's the first staff comment on page 2, just as a note for that. So page 2, line 13 provides that any covenant not to compete that restricts the right of any person to receive compensation for performance of skilled or unskilled labor shall be void. And then the next provisions are exceptions to that. So this voiding language would not apply to any covenant not to compete that's contained in a contract for the purchase and sale of a business or the assets of a business. Page 2, the staff comment is just a note kind of going back to the other version or the other bill draft, whether all assets or substantially all assets should be referenced here. Page 3, line 1, the voiding language would not apply to any covenant not to compete to the extent that it provides for the protection of trade secrets. The staff comment is just a note that the committee may wish to consider referencing the definition of trade secret that's included in the portion of the criminal code concerning computer crimes. That definition follows on page 3. Then page 4, line 6, the voiding would not apply to any contractual provision that provides for the recovery of the expense of educating and training an employee who has served an employer for a period of less than 2 years. And then page 4, line 11, the non-compete being void would not apply to executive and management personnel and officers and employees who constitute professional staff to executive and management personnel. This is, I believe, verbatim from Colorado law. Colorado courts have determined that whether someone falls within this exception is a question of fact. It requires an examination of what the job actually entails and not necessarily just a person's job title. And the question of whether someone is executive or management personnel is to be determined at the time the employee departs from that employment. Page 4, line 15 provides that any non-compete that restricts the right of a physician to practice medicine upon termination of the employment is void, but all other provisions that are enforceable remain enforceable. And then page 4, line 24 That last subsection just notes that after termination or voiding of a physician non-compete agreement, a physician may disclose his continuing practice of medicine to any patient with certain rare disorders that are defined in accordance with the national organization, to any patient that the physician was treating before leaving the previous employment. And then page 5, line 16, again, this act would apply only to contracts that are entered into or after July 1st, 2022, which is the effective date of this act. With that, I would stand for questions.
Thank you, Mr. Fuller. Questions for Mr. Fuller? All right, seeing none, let's go to Representative Stith. Welcome, Representative Stith. Good to see you again.
Madam Chairman, thank you very much.
So Representative Stith, do you have a preference over which bill draft you prefer? The one you
Well,
drafted?
yes. As you might imagine, I prefer 22 LSO 118 over 178. That is the version I prefer the version the committee's been working on over the summer, as opposed to the Colorado statute, as you might imagine. But I don't want to be totally negative about the Colorado law. So to focus for a second on what's good about the Colorado statute, potentially, or what's interesting about it. The carve out for executive and management personnel, that's an interesting policy choice because it does go to the idea of the problem you're trying to solve, which is that we think covenants not to compete can be unfair where there's unequal bargaining power between the employer and the employee, right? And that's kind of what the purpose of proposed legislation, 118 is trying to solve. So if you have a CEO of a company who's interviewing to work for a different company, that person might have more bargaining power and be more sophisticated than your typical line worker. And so there may be some policy justification for adding an exception for those employees who the committee or the legislature might deem to have more equal bargaining power with the employer. Okay. So in the Colorado statute, or 178, on page 4, lines 11 through 13 is where that appears. And Mr. Fuller just described it. It provides an exception for executive and management personnel and officers and employees who constitute professional staff to executive and management personnel. The particular language they've got here in the Colorado statute, I think, is really unfortunate. And it's generated quite a bit of litigation in Colorado. From my point of view, limiting it to high-level executives may make some sense, okay? But by saying both executive and management personnel, you sweep into this exception a whole lot of people who don't have particular bargaining power and who don't have particular high levels of responsibility within the company. And so my suggestion would be, if you want to incorporate this idea of top level management, it'd be my recommendation that you restrict it to top level management and not just make it, every assistant manager at the hamburger joint on the corner. Okay. So to give an example of that, in Colorado, there's a case called Dish Network Corporation versus Altamari, where Mr. Altamari, his job was essentially to supervise a crew that installed satellite dishes on people's roofs in Colorado, right? That's what he did. And so he then wanted to go work for DirecTV, and Dish Network sued him. And the court said that because he was running a crew supervising people to install these satellite dishes, that the covenant not to compete was enforceable and that he was management as a result of that. Whereas from the facts of the case, it's pretty obvious that Mr. Altamari didn't have any particular bargaining power in getting his job. And also he didn't really have any particular authority to direct the strategic direction of his employer, Dish Network. And so it seems like this case, Dish Network versus Altamari, is kind of an example of how this Colorado statute, I think, goes too far. The rest of the sentence also on page 4 of draft bill 178 includes not just executive and management personnel, but also officers and employees who constitute professional staff to executive and management personnel. That seems really unfortunate to me because it would mean that, you know, professional staff to executive and management personnel in a say you have a gastroenterology office, say, and you've got the anesthesiology assistant, for example. Well, that's a professional person. If you adopted this language, that would allow essentially the medical practice to tie up all of the nurses, assistant nurses, tie up anesthesiology assistants, et cetera, into covenants not to compete. So I think the draft language there about this sort of executive exception, if the committee wants to go that direction, I guess I would encourage the committee to narrow it so that you don't sweep, make it quite as broad as LSO 178 does. So that's the one big point I wanted to make. All of my other comments are pretty small stuff, actually, and I won't take too much time. I like the back to 22 LSO 118, which I think is frankly structurally sound. On page 2, lines 4 through 5, the staff seems to recommend that we add in sole proprietorship to the definition of business entity. And that makes a lot of sense, I think. I mean, I don't think you do any harm by that. If you had a sole proprietor who had a dry cleaning business and they wanted to sell it, it seems that it shouldn't, you know, it seems like that should qualify as well. No reason to exclude a sole proprietorship. So I guess I would be in favor if the committee so chose to add the words on line 4 of page 2 in draft 118, before the word partnership, add the word sole proprietorship or. I think that would carry out staff's recommendation. The other one thing about the Colorado, one thing I want to note about 22 LSO 118 on page 6, lines 13 and 14, which talks about the fact that this bill, if drafted, would not prevent an employer from recovering its actual expenses paid to third parties for specialized training of the employee. I want to contrast that language, which I think is relatively narrowly tailored, to the Colorado version. On page 6 of Bill 118, it's limited to the employer paying money to third parties. And the example I think of is if a welding company sends a welder and pays $15,000 to have them trained by a third party to do hot tap welding or something. If the employee then comes back and immediately jumps ship because now they're worth more to work for a competitor, I think it is fair for the employer to at least have the ability, if the employer has contracted for that right, to recover those expenses. But note that it's limited to actual expenses paid to third parties. Whereas in 178, if you look on page 4 of Bill Draft 178, lines 6 through 9, it's not limited to amounts of money the employer pays to third parties, but it says that the employer can recover, you know, that any contractual provision providing for recovery of the expense of educating and training an employee to serve an employer for a period of less than 2 years. The problem I see with the Colorado language there is that it's going to be really difficult to measure how much in-house training and how expensive that was. And also, I think there's a difference in training between the direct development of human capital for the employee, which is a real benefit to the employee, right? Like the welder who gets an additional certification. That's one thing, but a lot of training that employers do is really for the convenience of the employer, right? So if I hire someone in my office and I spend a week showing them where all my filing cabinets are and how I happen to file things, that's training that I'm doing of that employee, and that costs me time, and maybe I could value that at some great number, But really, I'm doing that for my own convenience. I'm not actually, my employee is not really gaining additional valuable human capital just knowing that I happen to, not file things alphabetically, that I file them reverse alphabetically or something idiosyncratic like that. So those are my thoughts on those two things. Finally, the Colorado bill, draft 178, the part that it deals with physicians is just truly bizarre and unfortunate, because think what this provision does. It's on page of 178, it's page 4, lines 15 to 22. The first weird thing about this is that it doesn't apply to doctors who work for hospitals. It only applies to agreements between physicians themselves. And so it automatically creates two different sets of laws for doctors, depending upon whether they work in a private medical practice or whether they work for a hospital. And that's just weird. And the other thing that I find odd about this whole physician thing is that, well, while physicians are special, I don't think they're so special that our law of non-competition or law of covenant not to compete should have some special carve out for them. I mean, I don't think they're that different from welders or nurses. So I think, it creates, so I'm not a big fan of the Colorado statute for that reason. So with that, I will stop talking and we'll stand for questions.
Representative Stith, thank you so much. Committee questions for Representative Stith? Representative Washit?
Thank you, Madam Chair. Good morning, Representative Stith. I think we covered this ground a little bit last time, but I keep coming back to it in my mind, and that is the fact that these employees knowingly enter into these contracts, and they have the choice at the time they go to work for a company to decide, do I or don't I want to work under this restrictive provision? And so I wonder, why do we need this statute if these employees are entering into these restrictive employment relationships voluntarily at the time of employment?
Representative Stith?
Madam Chairman, Representative Washit, that's a great question. I mean, certainly it's technically true that if I'm a freshly graduated nurse from Western Wyoming Community College and I go apply for a job at a home healthcare business and they present me on my first day of work with a document entitled Covenant Not to Compete. Yeah, I mean, technically I could get up and walk away and say, hey, I'm just not doing that. I'm not gonna work. I'm gonna go back to my job, as working as a fry cook and not be a nurse for you because I refuse to sign this, right? Yeah, technically, you've got the right to do that, but it seems that in that situation, when you're applying for a job, typically for most employees, the bargaining power is weighted pretty heavily in favor of the employer typically. It's not always the case. And so I want to acknowledge that there are some employees who at certain times or because of the scarcity of their skills have a lot more bargaining power. But it's also the case, and if you're you get your certificate as a welder from a community college, you got your training as a welder. You didn't get your training as a negotiator of contracts, right? And so you go to work and you want to start working. So Representative Washit, you're correct technically. You can always just walk away. But I think right now the law is tilted a little too much in favor of employers. Hopefully that answers your question.
Representative Stith, thank you. Always an option to go be the fry cook. Representative Yen?
Madam Chair, so Representative Stith, we just had a whole special session about protecting employees' rights. Think that this bill protects employees' freedoms of association?
Representative Yen, you had to go there. Representative Stith?
Madam Chairman, as much as I enjoyed the special session and found it a very rewarding experience, as did all of you, I don't want to belabor the comparison too much. I think Representative Yin is correct that what this does is it creates more fluidity in the labor market. And that extra fluidity in the labor market is good for the state as a whole. It's also good, I believe, to the extent that the state, through its institutions of higher education, invests in employees to give them human capital, such as training as a welder, training as a nurse, and that our current system has the effect of having that state investment often get exported out of state if a welder or a nurse effectively gets booted out of their service area and moves out of state. So,
Representative Rodriguez Williams.
Thank you, Madam Chairman. Good morning, Representative Stith. I'm looking at, I've got a background. I'm looking at the Colorado draft 178, specifically page 3, where the staff comment references the definition of trade secret and includes the criminal code concerning computer crimes. I'm just curious what your thoughts are about integrating, or the need to integrate some of that language or reference some of that language in 118.
Representative Stith.
Madam Chairman, Representative Rodriguez Williams, that's a great question. No, I really appreciated the staff comment. I think it could be a good thing to incorporate this definition of trade secret. I think that definition really does capture the thrust of what trade secrets are. And by adopting that definition, you could avoid litigation about what trade secret means. So I think it would be a good thing to graft that into sort of what I think of as my preferred version of the bill, which is the other one, 118.
All right, further questions for the representative?
Thank you. One follow-up question in regards to the staff comment under the definition of trade secret. It states it uses the word formula, pattern, device. When I look at the word formula, do you think that that might also apply to recipes? So say if you're a restaurant owner, do you think that would suffice?
Representative Stith.
Madam Chairman, I haven't done research on whether cooking recipes are considered trade secrets in other court cases, but generally speaking, I think the answer is yes. I think if you've got a garlic lemon Cuban pork that you serve at your restaurant, and you've got a special way of making it, and people really like that, and you've built up this clientele because of that, I think that could be your trade secret. I think trade secret, the hallmark of it is that it's something that's has some value that's not readily known to the public. Now, if it's possible, of course, that what you think of as your special recipe for, garlic lemon Cuban pork, is special. Maybe it's not. Maybe it's already in the public domain. Maybe Julia Child already described it, right? So, but yes, no, I think in general could include kitchen recipes.
Representative Stith, again, thank you for the entertainment this morning. Further questions for Representative Stith? Representative Oakley.
Thank you, Madam Chair. Good morning, Representative Stith. You said that currently, as it is, there's the power, the balance is too much in favor of the employers. But so I guess what I'd like to discuss is, do you think then that this goes too far? I mean, I know the answer to that, but I'd like some discussion on it. Declaring contracts void as a matter of law, does that swing the pendulum, too far the other way? And why do you think not, I suppose? And then also, does that increase that the remedy is litigation?
Representative Stith.
Madam Chairman, Representative Oakley, that's a great question. I mean, you want to be fair to the employers, which is why I think draft 118 has these two clawback provisions for employers. So like if the remedy becomes for the employer to get back their actual out-of-pocket costs of specialized training if the employee jumps ship, or to claw back potentially a sizable bonus if the employee jumps ship. And I do have some sympathy for the employers. So for example, our local hospital, because some years, I'm not sure exactly what their current practices are, but I know on at least one occasion they paid a hiring bonus of enough money that the new doctor was able to buy a Lamborghini and drive it around town here, right? And I think if that physician had then quit a month later and worked for the private hospital, the other hospital here in town, I think that would have been a raw deal for the employer. So as far as voiding contracts goes, I think it's important to note that this bill wouldn't void the employment contract completely. It would just say that, one, you can't put a covenant not to compete in your contract, but if you do, the contract is void just to that extent. So you do want to balance the interests of the employer in its investment, but what you don't want to do is to restrict people from being able to practice their profession. Because bargaining power, I think, is one of the core issues you're addressing, or the problem being addressed, and I wanted to be positive as I could about the Colorado statute, it may make sense if you want to have a carve out for the top level executives who not only would have more bargaining power in taking on the job, right, but who also, if they left the company because of their knowledge of the company's strategic intentions, might be able to do more damage to the company than a frontline employee. So, Madam Chairman, I don't know if that answers the question or not.
Representative Stith, I think Representative Oakley had a second question in there as well, which is increased litigation. Do you think that either of these bills will increase litigation?
Madam Chairman, thank you. Representative Oakley. What causes litigation, I think, is ambiguity. That's what really causes litigation. And so in Colorado, when they have this phrase management personnel, that's quite vague, that's caused litigation. Clear rules tend to avoid litigation. Sloppily drafted laws or unclear laws tend to promote litigation. And that I think to some extent independent of the policy course you choose. Our current system, because it's based on common law, is based upon a 13-factor system. And as we described in prior meetings, it's the very existence of 13 factors that makes it less predictable. And that lack of predictability, lack of certainty is the driver of litigation in my view.
Thank you, Representative Stith. Further questions for Representative Stith? Committee, it is 10 o'clock. We have 20 more minutes based on our agenda for this topic. So I think this is a good discussion, but would encourage you to be pointed in your questions and comments. Representative Washut.
Thank you, Madam Chair. Representative Stiff, just a quick question. Your comment my last question about the employee being presented with a non-compete contract on the first day of employment made me wonder, should we have somewhere in the law that such restrictive provisions need to be provided to a prospective employee prior to the first day of employment, so that the employer that has such a restriction must reveal that to the employee before the employee commits to the position? What would be your thoughts on that?
Representative Stith, your thoughts on adequate consideration?
Madam Chairman, Representative Washut. Yeah, you could do that. And I guess I just note the more prescriptive in a regulatory way you get to say, oh, you've got to give them 5 days notice before they can sign, or 5 days before they show up for work, they have to be given notice that they're going to be asked to sign a covenant not to compete, for example, or maybe even earlier, that when you make the offer, you've got to put it right in. that would be a provision that I think that would tend to lead to litigation, because then you'd have a whole bunch of disputes about whether that actually happened or not, right? With the employer typically claiming, yes, of course I gave them 2 weeks advance notice or a month's advance notice or whatever. And the employee saying, no, I never remember that, right? So I don't think that's a particularly great solution from my point of view. You could do that, I suppose. The other part is, look, what if everybody's doing that, then, and you're a welder and you want to get a job, but all of the companies, all of them have non-competes. If you want a job as a welder, then you're going to have to sign one of these things, whether you have 5 days notice of it or not. So I'm not sure the advance notice, really is an adequate or practical solution to that, from my point of view.
Representative Provenza.
Thank you, Madam Chairwoman. On page 6, where we are talking about the specialized training and third-party expenses for where this section should not apply to.
Representative
Representative Stitt,
Would you just identify which bill draft you're working in there?
I apologize. This is on 118.
Proceed. Yeah.
Okay, so we're talking about the third parties and specialized training in a situation where training is required, and then maybe the employee finds that the employer is awful to work for, or any sort of circumstance that might come up that they wouldn't have otherwise known before. Can you just walk me through what sort of maybe protections that employee can use in that instance? Or is that something that would have to end up in court? What routes could that employee take if they end up in that situation under this exemption?
Representative Stith.
Madam Chairman, Representative Provenza. So I don't think that the law is going to be able to prevent people from getting sideways with their employers, right? People are going to be unhappy at work sometimes. Sometimes they'll be less happy. Sometimes they'll be more happy. And that's why people want to leave often, right? I think it's just important to be fair, both the employee and the employer. Let's imagine my boss is a real jerk, okay, real jerk. But my boss also sent me to a 2-week training course that the boss paid for, that gave me an additional certification that lets me be more valuable in the marketplace. That's a real value to me. That's something I really got that's of some great value. And if I then quit and work for a competitor immediately after that, then I think the employer is sort of going to be sort of justified. Even if the employer is a jerk, I think they are sort of justifiably upset that they would have invested for no return, and in fact invested in someone that then is then used against them. I do want to make a comment about on page 6, those same lines, page 6, lines 13 through 17 of draft 118. This phrase "works for a competitor." Staff had questioned whether that needs to be there. I think it does, because you can imagine a situation where I get sent off to training as a welder, but then I get sick afterwards. I get multiple sclerosis or something, and I'm not working for a competitor. I'm just not showing up to work because I can't. So I think the current draft is relatively narrowly tailored. So to answer the question, I don't think that this bill is going to create a kumbaya atmosphere in the workplace for everybody, but I think it would be substantially fair.
Representative Stith, thank you so much. Further questions for the representative? And Representative Stith, if you would just stay online with us and stay on Zoom as we work through public comment and the bill, I think that would be most helpful and productive. With that, we'll go to further public comment on the bill. Is there anyone who'd like to come testify on either bill draft? Welcome. And if you would identify which bill draft you're speaking to, that'd be most helpful.
Thank you, Madam Chairman, members of the committee. I will do that. My name is Tammy Johnson. I'm the Executive Director for Wyoming State Afl-Cio. And boy, do I have a solution for this employer-employee strife we're talking about, but we'll get to that later. Looking at these two bills, I'm most concerned about the exceptions and the provisions that hit employees once they're in the workplace. So looking at at 118, which is the Wyoming draft, I think, when we look at lines, page 6, lines 13 through 14, I wanted to point out what's good about this particular section, and that is it has some pretty clear sideboards. You're going to work for a competitor. The training is specialized, and the actual expenses are paid to a third party. So let's contrast that with what's in 178, the Colorado version, which has no sideboards on it. And it just says that, let me get there. The recovery of the expenses of educating and training an employee who has served the employer for a period of not less than 2 years, less than 2 years. So there's no sideboards there. So that's problematic because we have a lot of industries that train employees, and the fast food industry trains its employees when they come in. And they're pretty desperate for workers right now. And this would restrict the mobility of those workers because, and this also, I'm very concerned because this also encourages those hiring agreements to be implemented and signed now, which I don't know. I thought I might go apply for a fast food job yesterday just to see what the process was, but I didn't enough time. So, because I think that if they don't do that now, this encourages them to do that in order to hang on to those employees. The training that's provided in 178, the training is not specified. It's not paid to a third party. It could be on the job training. And so an employer could say, yeah, we have real costs around on the job training, and we're going to recoup that if you leave before this time frame. I don't know what's so unique about this particular 2 years or 3 years. I know that once an employee receives training and they begin working for an employer, the employer is immediately benefiting from that training. So perhaps a proration or a sliding scale if a clawback is needed. But with no sideboards on the provision that's in 178, I think we're opening up a whole different class of workers to some real difficult challenges. And I'm very interested in Representative Stitt's comments, and he and I have talked a little bit about this bill and the provisions, but I'm really interested in the comments about the disparity in bargaining power between certain levels of employees and others. And I think he hit the nail on the head. And Representative Washut, to your point about knowingly entering a contract, many employees who are in lower wage jobs who may be asked to sign these contracts may not have the knowledge or the whereabouts. And that may be sign this on the dot. You know, I've been to jobs where they've said, here's your employment agreement, sign this, and you don't get to look at it. And I don't know if that's practicable in some of our lower wage job industries to say, we want to hire you, take this home and read it over, have your lawyer look at it and get back to me. People in management certainly have access to those resources. They have that level of education and training, but people in lower wage jobs don't. And so I'm very concerned about the open-endedness of the provision on page 4 of draft 178. And I do have a suggestion for that. I appreciate that Representative Stitt addressed subsection Romanet 4 in 178, because that second half of that provision that says employees who constitute professional staff to executive management personnel, their desire is to move up in the workforce. And if they are held to a provision in a law that says you don't get to go work somewhere else, and if you do, we're holding you to a non-compete, I think that's very unfair, especially in Wyoming, where you may not be able to move up in the company that you work for here, but there's a job opening over there, and that could help you move up into management. So we're going to restrict those typically younger, lower wage employees from moving. They may be stuck in a company where there's no upward mobility. So those two things concern me a great deal about 178. A couple other things to point out under IRS code, training and education are deductible for an employer. So if the employer does send that person out to get the $15,000 welding, part of that or some of that may be deductible. That's also true of bonuses. bonuses are deductible by the employer, and they're also taxable income for the employee. So I think you run into a mess of what's realized gain for the employer and the employee when you do a clawback on something like that after the fact. I do know that many of the industries here in Cheyenne that you see are advertising hiring bonuses, they're paying those out in paychecks over a short period of time. So while it might say, you know, we're giving you $1,000 hiring bonus, that's going to be spread out over a certain amount of time. And so to say that the employer could claw that back after the employee has actually worked that off and not received all of it is a little disingenuous, I think, on the employee's part, on the employer's part to have that safety net. So I think that's everything that I wanted to comment on. I think that training costs are the cost of doing business. And I know I've been in many, many jobs where I've been provided training, and that's my employer built that into their, you know, their budget. And that's part of what they consider the cost of doing business. They get something better out of the product when they send employees to training. I do know that in the union world, when a welder, say, has to go get extra training that's not provided through their apprenticeship program, the union makes an agreement to help support and pay for some of that training. So there are other options for employers to not have to be on the hook for all of that. But those things are best left, I think, between the employer and the employee. And in a real world where bargaining power is equal, those contracts can be negotiated. There's a very big difference between what we traditionally think of as non-competes for that doctor who's getting the Lamborghini, and then the people who are working at some of those lower wage jobs. And these bills don't specify between those, and that's a concern to me. So I appreciate you hearing that.
Ms. Johnson, just a couple quick questions. Thank you for being here, and thank you for reviewing these bills so carefully. Do you think that these bills, either version of them, protect or harm employees, just generally speaking, under Wyoming's current law?
Madam Chair, I think I can't speak to how they are currently under Wyoming law. I'm just concerned about what these are. I apologize for that. I haven't had time to go back and look at all that, but I see a clear disparity in impact on lower wage earners and higher wage earners in what's presented to you today to talk about. So I think in some regard, a non-compete is great for, I mean, eliminating the non-compete is great for many workers, but at the same time, when you put exceptions in that target certain classes of people or certain classes of workers, that's more difficult. I don't see someone in management, an executive, going out and getting training. It typically isn't done. They're hired because of the training that they already have and the success they have. But the training is typically targeted at lower wage earners who need to build their skill set and step it up. The other interesting thing in these bills is that the first bill, I think it identifies a worker as a labor. Let's see, I wanted to pull that real quick. It identifies subsection A only applies to skilled or unskilled labor. And I didn't know if you were intending that to apply to the definition in Wyoming statute 16-6-202 AI, labor means a person employed to perform unskilled or skilled manual labor. And so I know that it doesn't say that specifically, but if you look at the other statutes, how we define laborer, there's a little bit of a really scoping this down to be skilled or unskilled manual labor. And that, again, is typically a lower wage earner.
Thank you, Ms. Johnson. Questions for Ms. Johnson? Representative Washut.
Thank you, Madam Chair. Can you tell us how many employers in the fast food, low-end type of positions that you referenced actually use non-compete contracts with their employees?
Ms. Johnson, if you know.
Madam Chairman, Representative Washut, I do not. I am concerned that the language in this bill would inspire them to start using this kind of an agreement to hang on to employees, because now it can apply to their employees.
Representative Washut.
So would you prefer we not pass either of these and just leave us with existing situation?
I do have one I prefer written. I wonder if you'd like to hear it. I w-
Briefly.
Sure.
We have 3
and I'm-
minutes left on this topic, so if
I
you can do it
know.
in less than 2 minutes, that'd be great.
I can. Sheets all mixed up here. Feel like I'm back in law school.
And if you
Nothing's in the
could,
right
you're
place.
fine, Ms. Johnson, if you could raise your hand in the room right now, if you intend to provide testimony on this bill. Just one of you, great. Is there anyone online? Great.
Cool.
When you're
Well, 2
ready, Ms.
minutes.
Johnson.
I would suggest if you go with version 178, that you strike subsection AII entirely. And so there would be no provision for clawback on training. That is left to, that it's considered a cost of doing business. I would also suggest, if that doesn't work, then I would suggest that you put some sideboards on it. In 178, the Colorado version, that you put the sideboards on that you have in 118. I'm getting those mixed. Yeah, I got that right. Yeah, so that you include those sideboards so that there are some specifications. I would even say maybe identify some NACE codes that you want this to apply to, because there's a lot of, right now it's wide open for any career. So, I mean, you could even say this could apply to teachers who often do lots of training. I mean, there's just so many careers require you to get training to stay employed. There's no provision if you're fired or if you quit voluntarily. There's nothing in there that says that. I would assume that the intent is that not if you're fired, but if you leave voluntarily, but that's a problem. And then on subsection, let's see, in 178, on the provision for the managers, and subsection A, Romanet 4, lines 12 and 13, put a period after officers and strike the remainder of the section. So the section would read, the exception applies to executive and management personnel and officers. And so we leave those lower level support staff people out, that they are not subject to that. So they can't be held to a non-compete.
Thank you, Ms. Johnson. Any questions for Ms. Johnson? Ms. Johnson, thank you for being
You
here
bet.
this morning.
Thank you. I
Thank you for your
apologize
review.
for being late in the game. I watch labor, I watch all these other committees, and I forget to watch you guys. So I appreciate
We're
that
the
you-
number one committee.
I know you are. I'm going to watch you more closely now. So,
Thank you, Ms. Johnson, for being here. We appreciate your comments.
yes.
All right. Mr. Hannes, please welcome to the committee.
Madam Chairman, members of the committee, Josh Hannes with the Wyoming Hospital Association. I'll be very brief. One general comment is that I'm not sure I see a problem so prevalent in our state that it requires new legislation. But that being said, and I guess now I'm probably referring more to the Colorado version of the bill. I think there's been some recognition from the bringer of the bill in this committee that should this move forward, that there are positions and professions that have equal bargaining power along with their employer, and there should be an exemption for those. In the hospital setting, non-competes are really limited to physician contracts, not lower mid-wage earners. These are almost exclusively with physicians. I would argue that physicians in Wyoming have tremendous bargaining power and would fit in, as seems to be agreed upon with some members, that along with executive management, that there should be some consideration that hospitals continue to be allowed to use such a tool should they desire when negotiating with physicians. Those are my comments, and I would stand for questions.
Questions for Mr. Hannes? Representative Oakley.
Thank you, Madam Chair. My question, are renewals used? Something I don't feel like we've discussed, but I'm interested in is, it's one thing when it's the initial, beginning of the contract. Is that something that is used in order basically so it becomes indefinite?
Mr. Hannes?
Madam Chairman, Representative Oakley, I don't know. I'm happy to get some information and report back to you.
Great. Thank you. Thank you, Mr. Hannes. Senator Kolb.
Well, thank you, Madam Co-Chair. Just a general question about the nurse situation. I think that is certainly going to be a larger issue than it was currently because of the shortage of nurses. Would there possibly be, this restriction, as we've heard of it before, on nurses' inability to, say, leave employment with some sort of employer-employee contract? What was your thoughts on that? Thank you.
Mr. Hannes?
Madam Chairman, Senator Cole, I do apologize. I'm not sure I totally followed that question.
Yeah, excuse me, Mr. Hannes, if I may. So Representative Stith, when he originally brought this concept forward, brought it primarily out of a situation that occurred, I believe, in Sweetwater County, where a nurse, I think, was prohibited from getting additional employment as a result of a restraint on her ability to do that from a covenant not to compete. Representative Stith, do you want to provide some additional background?
Madam Chairman, that's
Briefly.
yes, that's substantially accurate. There's actually 3 nurses in Uintah County who had signed covenants not to compete as a condition of getting of their employment. And so the public policy there, I think, relates to harm to the public, that it's not just the employee who's put at a disadvantage, but the public who doesn't get the services potentially. And I think that's true for physicians too, that physicians probably have more bargaining power, but it's also not great for the community if their physician that the patients have come to rely upon, suddenly that physician leaves the state.
Mr. Hannes?
Madam Chairman, so those cases were, as I understand them, in a home health agency. Typically in hospitals, non-competes are not a part of a nurse's contract. I'm not going to sit here and say it never happens. I don't know, but that's not typically the practice in a hospital setting. But for physicians, and I guess what I'm asking for is the ability to use this tool or not, based on the facility's desire as they're contracting with physicians, who have who are on equal footing in the negotiations. Certainly a hospital and a nursing home is not going to put their community at a severe disadvantage, particularly now when staffing is very short. It's hard to come by, and we invest a lot of money in recruitment, retention, hiring bonuses. Right now, there's a lot of work that goes into that. So again, in hospitals, it's not typical for nurses to have those provisions, but we would ask to have the tools available at least for physician contracts in those negotiations. And I hope that answers the question, Senator Cole.
Senator Cole, you good?
Well, my point is that there, as I understand, currently I was wanting your verification that there's a critical nursing shortage right now. And there's basically an issue with that. And I was concerned that if we didn't address it, it may get exacerbated and become a bit larger issue. And I thought you might have known more about that as it pertains to the nursing shortage. Thank you.
Mr. Hannes?
Madam Chairman, I don't know that I have more to say on that issue other than this is just not a typical practice for us in nursing in the hospital setting. So we're doing a lot of things right now to try to adjust that shortage and maintain our workforce. But and I guess I'll go back to my first comment too, is that I don't know that I see something happening in the industry right now in hospital nursing homes that require a change to law.
All right, any final questions for Mr. Hannes? All right, seeing none. Thank you, Mr. Hannes. Further public comment on this bill? Seeing none, public comment is closed. Committee, back to you. Let's start with 22 LSO 178 version 6. Is there a motion on the bill? Seeing none, that bill has failed for lack of action. Committee, let's go to 22 LSO 118 version 6.
I move the bill.
Moved by Senator Kolb. Is there a second?
A second. Representative Larson.
Seconded by Representative Larson. Thank you. Discussion on the bill, amendments?
I would propose an amendment to, if I may, Madam Co-Chair.
Senator Kolb?
Yeah, on page 2, under line 2, Romanet I, business entity, to insert sole proprietorship where it's deemed appropriate. I don't know if that would require a C being part of that description or not. Is that explanatory enough, Madam Co-Chair?
Yes, Senator Kolb, to add sole proprietorship to the list of business entities. Is there a second to that motion?
I'll second that.
All right, seconded by Representative Larson. Discussion on the amendment? Seeing none, all those in favor say aye. Any
Aye.
opposed? That motion has passed. Further amendments? Senator Cooper.
Yes, ma'am. Thank you, Madam Chair. On 118, page 7, line 4 through 6, I'd like to amend that 3 years down to 6 months, please.
Page 7, line 6, Senator Cooper's motion is to amend the 3-year period down to 6 months. Is there a second on that motion? Seconded by Representative Vien. Discussion. Senator Cooper, do you want to explain your thoughts?
I feel like 3 years, excuse me, Madam Chair. 3 years is a pretty extended time for that hiring bonus to be recouped. The employer will get benefits from the employee over that initial period, and I think that a 6 months period is adequate for that employer to recoup his costs. Thank you.
Further discussion?
Madam Chairman, Representative Larson.
Yeah, Representative.
I'm against that motion. If I think that's too short. So if the bringer would accept a motion or an amendment toward the amendment to make that 1 year.
Senator Cooper, do you find that friendly?
Yes, ma'am, I do. My thought process here was to initiate discussion on this, so absolutely.
So the motion now is, committee members, on page 7, line 6, to change the 3-year provision to 1 year. Further discussion on the motion?
Madam Chair.
Senator Kolb?
Yeah, I got a question to the bringer of this amendment. What happens if I guess your employment time period was set such that your bonus was paid out for 1.5 years? I mean, I wondered if 1 year seems a bit short to me. I mean, granted, I think is it reasonable to question 3 years, but 1 year seems short. And I wondered, could you expound more on the impacts of that change to 1 year as opposed to 3 years? Thank you, Madam Co-Chair.
And we'll go to Representative Craigo and kind of stack up some of these questions for Senator Cooper.
Madam Chairman, thank you. I guess I really don't have a question other than to point out, I think at the last meeting, it was actually 2 years and we amended it up to 3, but don't have a comment one way or the other.
Depends whether we've had breakfast or not. Representative Craigo. Senator Cooper, do you want to comment on the 1 year period?
Thank you, Madam Chair. I don't know if 1 is too short or 3 is too long. I just think this deserves serious discussion. Maybe we need to go back to that 2-year number, and the other options is to strike it completely, but I don't think that's right. I think there's a need for the employer to recoup his cost. 3 years is quite a while.
Well, good members of the committee. I think the challenge that we're struggling with here is kind of our reluctance as legislators to tell private business what makes sense for their particular business decisions, which is usually an area we try to avoid, although not of late. But nonetheless, this is very prescriptive on private business as to what period of time they would be able to collect a bonus. And this would include all types of employment. So pretty broad prescriptive prohibition by the legislature in private business. So something to consider. Representative Craigo.
Thank you, Madam Chairman. I guess one more comment is when we amended it from 2 to 3, I know we were specifically talking about physicians at that point. We talked about hiring bonuses paid to physicians. If we end up exempting those type of professions out of the out of the bill, out of the law. That will change the impact of that 2 versus 3 versus 1. I think that's something we need to think about as well.
Further discussion on the amendment, Senator Cooper?
Thank you, Madam Chair. I would have to agree with what Representative Craig commented there. There's a lot of difference between recouping $1,000 or $2,000 hiring bonus and a $20,000 or $30,000 hiring bonus. And I'm not sure how we address that prescriptively here, because it's a pretty tight window, and I'm not sure how we do that fairly across the entire spectrum.
Senator Cole?
No comment. I'm just listening to what Senator Cooper has to say and considering it.
Your hand's up.
Oh, well, I'll put my hand down.
I am going to take the Liberty Committee and turn to Representative Stith, who is a former member of this committee and of course been with us throughout this conversation. Representative Stith, the committee is in closed discussion on an amendment, but you have been involved with this process every step of the way. Any thoughts or guidance you'd like to provide?
Madam Chairman, I don't take a position on the amendment, but I would say I think that for the low line employees who get, say, $1,000 bonus to start as a fry cook because there's such a labor shortage, it's really unlikely that the hamburger franchise is going to go to the effort to try to collect that and claw that back. This clawback typically is only going to happen if it's a substantial bonus, I think. So I think when this provision is actually going to come into effect and apply in the real world would be if someone's paid a pretty hefty bonus to start. And I guess I just leave it to the committee to decide whether you think 1 year, 2 years, 3 years. I don't have a real strong opinion one way or the other about that.
Very helpful, Representative Stith. Representative Larson?
Madam Chairman, thank you. Would it be okay if I asked Representative Stith a question I should have earlier? Is there any way that he might think we could put in a percentage payback in this? I just don't know where to put it or how you would word it on a percentage on a time basis.
Representative Stith?
Madam Chairman, Representative Larson, that's a great idea and makes the bill potentially more complicated. But yeah, you could say you can only claw back 50%, or you can only claw back X percent if they leave in the first 6 months, and then if they're there for 2 years, then you can only get a quarter of that or half of that or something. You could make this, which would seem perhaps be more balanced. Frankly, you could apply that same idea to the training expenses too, to say, hey, the employer can only get 50% back, say, or have it be on a time scale so that if I leave my employment immediately, the employer gets 100%, but if I stay there for a year, they only get 50%. Sure, you could mix and match all day long. And I really just want to say thank you to the committee for even considering this. I think this is a really tough issue. It's a tough issue to get right.
Thank you, Representative Stith. Let's keep our options limited, not overwhelm the committee. We're not at Starbucks this morning. So let's keep it simple. Back to the committee. We're on the motion to change it from 3 years to 1 year on page 6. Question being called. All those in favor say aye. All those opposed say no.
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 That motion has failed. Committee further amendments?
Madam Chairman,
Representative Larson?
I'd like to do a conceptual amendment and make it so they could only claw back on both items a percentage over on a percentage basis over a specified period of time. So like for the 3-year period, you could do 100% right away, and that percentage went down over the 3-year period. So I don't know where to put that is my biggest issue. I don't know if you'd have to put that on each item in like item A, and then also on in item B.
Is there a second? Is there a second? Seeing there is no second, that motion has failed.
I think Senator French.
Senator French has seconded the motion. Mr. Fuller, comments?
Madam Chairman, Representative Larson, I think I'd probably put it in both paragraphs. The bigger question I have, though, would be, I don't think it should be, I think it should be left to the committee right now to decide what percentages for what particular time periods. So that clarity would be appreciated.
All right, there's a second. Further discussion from the committee. Senator Cooper?
Thank you, Madam Chair. A question for the bringer. Is this really necessary on the section A, or should we be more referring to section B, the hiring bonus?
Further discussion on the motion? Seeing none, all those in favor, please say aye. Oh, wait, I'm sorry, Representative Larson?
Madam Chairman, yes, I'd like to comment on that. Yes, I think it ought to be in both A and B. And as I specified it, I think it should be as a percentage basis over the whole time. And so every month it would change probably, or every day. I think it can be read in there that way. Thank you.
Further questions for Representative Larson? All right, seeing none. Question having been called, all those in favor, please say aye.
Aye.
All those opposed, no.
No.
That motion has failed. Committee, back to you. Further amendments. Representative Yen.
Madam Chair, I'd like to give a little less of a prescriptive option. I'd like to amend on page 6, line 13, after A, write up to 80%. And then on page 7, line 4, add up to 80% after B. And that way it gives the employer, well, I'll let a second and then I'll explain a little bit more.
Seconded by Representative Wanitzer, cautiously.
Madam Chair, yeah, so my intent is, I think the up to language needs to be there anyways, because otherwise you're only allowing for a contract provision that is 100% expenses paid or nothing, or not have that contract provision at all. I don't read this as allowing anything in between, to be honest. And I think the 80% number is just good, because the employer will get benefit from the training unless unless the person leaves immediately. And the same with the hiring bonus as well. And I think 80% is a reasonable number to put in there for that.
Further
And it
discussion.
allows them to structure somewhere in between. And if they want a declining basis for whatever reason in their contract provision, this change would allow for that.
All right, thank you, Representative Yen. Further discussion? Representative Wanitzer?
I just have a question for one of the attorneys. If this was litigated, I'm just not sure I agree that it's an all or nothing. Wouldn't a court perhaps award a percentage in the court's discretion? Or for my learned colleagues of the law, do you read it the same way, that it's an all or nothing provision, the way the statute is currently worded?
Representative Craigo?
Thank you, Madam Chairman. I guess I would probably agree with Representative Yin that it is all or nothing. It doesn't really, it says actual expenses paid and actual cost of the bonus, which to me sets some certain either way.
Mr. Fuller, your thoughts, if any?
Madam Chairman, I would just note that it's silent on the question. It doesn't, it just says any, the intro, page 6, line 10, any contract provision that requires an employee to reimburse an employer for, and then after that it's silent on the percentage. It could be argued actual expenses. It could be, argued that, a contract that says you're going to repay X, if X represents some portion of the actual expenses, whether a court would, stick to, actual expenses, meaning all actual expenses. I guess I'd note the word all is not, currently in the bill draft.
All right, thank you, Mr. Fuller. Further questions on Representative Yan's motion? Question being called. All those in favor say aye.
Aye.
All those.
Aye.
opposed- Raise your hand if you're voting aye. Online as well, just raise your physical hand. All those opposed, no? Then raise your hand. Raise them high.
I got it.
Okay, that motion has failed. Further amendments? Representative Craig.
Madam Chairman, I guess this might be a bit of a conceptual amendment as well, but I'd like to pull some of the language out of draft 178 regarding the executive and management personnel.
I'm not in favor.
Put that in, it would probably go in on page 7, would be Romanet 4. Essentially, it would say any contract between an employer and executive and management personnel.
Senator Cole, mute your mic. Preventing any issues. Thank you. All right, Representative Craig, could you repeat that?
Yes, ma'am. Thank you, Madam Chairman. So it was along the lines of the discussion regarding executive and management personnel, and pull that, some of that language out of the 178 draft and put it into the 118 draft. I think it would go on page 7, Romanet 4, line 7, page 7. We'd have to create a Romanet 4 and essentially say any contract between an employer and executive. I can't remember.
So
Executive
on-
and or management personnel.
Yeah, page 4 on Bill Draft 178. I believe Representative Craig would like to take the concept associated in lines 11 through 13 on page 4 and place them into 118. And we're kind of discussing that, how that would apply. On this topic, I think Representative Stith was concerned about this, just to remind the committee, Colorado case law interpreting what management personnel was, and the example in that Colorado case was a TV satellite installation crew supervisor essentially was determined to be management personnel. So as we work that into 118, be, I guess, mindful of that knowledge and that language. Representative Craig, where do you think that provision would go?
Madam Chair, I think it would go on page 7, line 7, and it would, well, it could go anywhere, but it could logically fit in there as a Romanet 4, because starting on the bottom of page 5, we have all of the places where the bill does not apply. So subsection B, the prohibition on non-competes would not apply in that particular situation.
And do you want that language exactly as found in Bill Draft 178?
Well, actually, no. So what I understood Representative Stith to say, and maybe he can chime in here in a second, was that the second part of that language where it talks about employees who constitute professional staff to executive and management personnel. I think that was the language that to me was more confusing than just executive and management personnel. Period. Could also apply to officers of the company, and we probably should include that too. So it could say executive and management personnel and officers of the business entity, period.
Is there a second to that motion? Does everyone understand it? You want further clarity on the motion? All right, it's been seconded by Representative Oakley. Representative Stith, did you want to provide some comments?
Madam Chairman, Representative Crago. So the litigation in Colorado Dish Network versus Altamari centered on the issue of whether Mr. Altamari was a member of management or not. And because the Colorado statute doesn't really define management, it's led to litigation about what that is. So to me, it makes a lot of sense to exclude executive personnel. That makes sense to me, the CEOs, officers of the company, that makes sense as well. You know, my preference would not be to include management, just because I think the assistant manager at the burger joint, would fall into that. So in any event, but that's just my take on it. Thank you.
All right, further discussion, Representative Zwanitzer?
Just some more discussion. I'm not sure who's left that we would be putting under a contract if anyone in a managerial role, I mean, whose job description does non-competes? I don't think it's the two fast food restaurants in a community. I mean, I suppose they could and go an all-out war, but if you're taking out the people, when I think of non-competes are skilled trades, executive, I mean, people who have a higher level of either education or skilled qualifications. I'm not sure who's left under the amendment besides competing retail.
Representative Craigo?
Thank you, Madam Chairman. I guess the issue I'm trying to get to is who has the bargaining power, who has the ability to deal with their employer and who doesn't. And I think this was the conversation Representative Stith was having with the committee earlier was how do we narrow that down? I mean, the point is we're trying to protect those people who don't have that bargaining power, who don't understand what they're signing. And I think there's still a lot of employees out there in the workforce who it would apply to. I don't know how many, obviously, but I think that was what I was trying to get to and what the conversation was about.
Representative Yin.
Madam Chair, thank you. So maybe a question on the nursing issue again. Do nurses have staff under them? And if they have any subordinates at all, does that consider them as management under this amendment?
Representative Craigo, your thoughts?
Madam Chairman, thank you. I suppose it could actually, and I'm just pulling that language out, from the Colorado statute. We can narrow that more. We can obviously limit it to executive staff if that's what we want to do as a committee, just pulling that out of the Colorado language.
Further discussion?
Madam Chair.
Senator Kolb?
Representative Craigo, would you consider it a friendly amendment to strike management out of your proposed amendment?
Representative Craigo?
Madam Chairman, thank you. Yes, Senator, I would.
All right, does everyone understand the motion now? I believe the motion is, okay, I want you to go to page 4 on Bill Draft 178, lines 11 through 13. And the motion is to take that language that's now been amended that would say executive and officers of the corporation who constitute officers of the corporation. Is that it, Representative Craigo? Executive and officers of the corporation or business entity.
Madam Chairman, yes.
All right, executive and officers of the business entity. And that would go on Bill Draft 118 on page 7, on line 7. That's the motion. Question being called. All those in favor say aye.
Aye.
Are you going to vote, Representative Craigo? I'm going to need everyone to vote loud. All those in favor say aye.
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 All those opposed say no. Division, the chair is in doubt. Everyone in favor, please raise your hand. All those opposed, please raise your hand. That motion has passed. Further amendments on the bill? Representative Rodriguez-Williams.
Thank you, Madam Chairman. I move an amendment on page 6, line 6, after the word trade secrets, conceptually that we add reference to the definition of trade secrets, specifically out of Working Draft 178, page 3, as defined in the staff comments.
All right, that's been seconded by Representative Washut. One thing that I would remind the committee is no more conceptual amendments. We are on our last day of our last meeting, essentially. with to sponsor a joint judiciary committee bill to take into the session. So that gives too much discretion and puts our LSO staff in kind of in a troubled spot by having to interpret what we're trying to do. I think we can make this an actual amendment by saying that we are adopting the language from 178 and placing it in 118. And let's just decide where that's going to go and take the time to do that. So let's just take a minute and look in 118 and determine where that can go. And we'll hear from Mr. Fuller.
Yeah, Madam Chairman, I understood and Representative Rodriguez Williams, I understood the amendment simply would be page 6, line 6, after secrets, insert as defined by WS 63501A11.
Wonderful. Representative Rodriguez Williams, is that your clear express amendment? I think she said yes. All right. Thank you, Representative. Appreciate that. Further discussion on the amendment? Question being called. All those in favor, please say aye.
Aye.
All right. All those opposed, say no. That motion has passed. Further amendments? Representative Yen.
Madam Chair, I am going to try one more time with actual expenses paid. I would like to make the same amendment, but without the 80%. So it would read up to the employer's actual expenses. I think the ambiguity provided by the lawyer on the committee and the lawyer on our staff means that there would be litigation if we didn't have that unambiguous.
What page number are you on, Representative Yen?
Page 6, line 13, add up to after A, and on page 7, line 4, add up to after B.
Is there a second? Seconded by Representative Oakley. Discussion on the amendment? Representative Craigo.
Madam Chairman, thank you. I'm wondering if that doesn't actually create more chance for litigation when you use the words up to. And the reason I say that is, does that mean that what the employer gets to withhold to decide how much they go after? Does that mean that the employee gets to decide how much they pay back? I don't know. It might. I'm just wondering if it doesn't create more chance for litigation than less.
Representative Yen.
Madam Chair, so my hypothetical, really bad at big words today. My hypothetical scenario is that you have a non-compete clause, and in that clause it says, I will claw back 50% of the hiring bonus if you leave within whatever number of years. And the employee, once they decide to leave, says, I don't have to do that. It falls under our non-compete exclusions in this bill, and it doesn't fall under the exception because it isn't all of the actual expenses. And I think that would lead to litigation, Madam Chair.
Further discussion? All right, seeing none, sensing you're ready for the question. All those in favor, please say aye. Aye. All those opposed say no.
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 Chair is in doubt, please raise your hands. All in favor? I think you changed your votes. All right. All those opposed, please raise your hands. That motion has failed. We'll talk louder.
Question on the bill.
Any further amendments, committee? Where this gets sponsored as a joint judiciary bill? All right, seeing none. Question having been called, roll call vote, Mr. Fuller.
Senator Cooper,
No.
Senator French,
Aye.
Senator Kolb,
Aye.
Senator Cost,
No.
Representative Craigo, Representative Larson,
Aye.
Representative Oakley,
No.
Representative Provenza,
Aye.
Representative Washut,
No.
Representative Rodriguez Williams,
Aye.
Representative Yin,
Aye.
Representative Swanitzer, Chairman Nethercott,
Aye.
Co-Chairman Olson.
Aye.
That does pass.
That bill has passed. Members of the audience and committee members, I did vote aye on that bill. It is, but I may not vote aye and carry it through in the session, and that's pretty rare to do. I do think that this conversation and this topic is important for Wyoming. I am aware in my own practice and in concerns in the state that this continues to be an issue. I believe Representative Stith has appropriately brought this issue to the committee. So I do think it deserves a longer and more warranted discussion that is appropriate in the session. But I do think it's a significant policy consideration for the legislature to be coming into this private business space. So
Madam
with that,
Chairman,
Representative Larson,
what was the tally? Vote.
Madam Chairman, Representative Larson, I had 9 aye, 5 no, 6-3 House, 3-2 Senate.
all right, with that, we're going to go ahead and take a quick 5-minute break, committee members. Please come back at 5 minutes. We're going to stick into this so we can get done on time and early. We still have additional work to do about that noon hour timeframe. 5-minute break. You know what it is. Representative. We're going to go ahead and start with Mr. Fuller walking us through 22 LSO 121, Working Draft Point 5, Dissolution of County Boards Authority. Mr. Fuller, if you'd go ahead and begin.
Yep, Madam Chairman, members of the committee, the committee considered this bill draft in September and requested changes. Generally, it clarifies that the Board of County Commissioners has the authority and may dissolve certain county-created boards, and then it specifies requirements for the dissolution of those boards. So just to walk through quickly, page 2, line 1, just provides that each Board of County Commissioners may dissolve any board or district that's created under certain statutes. Those are the Board of Trustees for Fairs, Pleasure Grounds, and Airport Parks. And then also references to solid waste districts and archaeological museums. And this is the process. So page 2, line 5, not later than 120 days. And that is a change the committee requested from the last meeting. Previously, the draft read not later than 180 days. So now it would read 120. The board must publish not at least 2 times in the county designated newspaper a plan to dissolve and terminate the board. The plan must provide for the payment of all bonded and other indebtedness against the board or district, the disposition of assets of the board upon dissolution. The staff comment on page 3, there was discussion regarding language in these special district statutes for the dissolution. And the language on page 3 is an attempt to work that to kind of redraft that language in a format that may work for this bill draft based on that statute. The entire text of that statute, 22-29-407, is on page 4. Then moving on to page 5, not later than 30 days before the proposed dissolution, the Board of County Commissioners must hold a public meeting, provide opportunity for public comment. After that public notice and comment, the board either disapproves or approves by resolution the plan for dissolution and termination. Page 5, line 13, upon the approval and passage of a resolution that dissolves the board, that board must take all actions necessary to effectuate the dissolution plan and to dissolve and terminate the board or district. Page 5, line 21, not later than 90 days after the passage of that resolution, the board or district terminates its existence. The remaining changes in the bill are conforming amendments. So page 6, lines 13 to 16, this amends the general powers of the Board of County Commissioners to dissolve any board in accordance with that previous language. Then on page 7, lines 6 to 7, this authorizes a Board of County Commissioners to dissolve any board that's created under that subsection, which would be the fair boards and airport parks. Page 7, lines 16 to 18 is that same authority for dissolution for any archaeological, geological, or historical museum that the board has created. And then finally, page 8, lines 1 to 3 is authority to dissolve any solid waste disposal district that's established. With that, I would stand for questions.
Questions of Mr. Fuller? All right, seeing Senator Kolb.
Thank you, Madam Co-Chair. Mr. Fuller, on page 2, line 16, the disposition of assets, and it speaks to board or district upon dissolution. Would there be any conflict with the current fact that the Board of County Commissioners in some of these cases wholly own all said assets? Would that cause any conflict in the future in the courts? Just looking for your opinion. Thank you, Madam Co-Chair.
Mr. Fuller?
Yeah, Madam Chairman, Senator Kolb, I'm not sure it would. I think that just, if the assets are held by the county, I think that would remain the same. This would be assets of the board or district, which I would take to mean those that are either owned or that are owned by that board or district.
Senator Kolb, you okay?
Yeah, I just wanted to clear that up in my own mind. Thank you.
All right, any additional questions for Mr. Fuller? All right, seeing none. Do we have the County Commissioners Association is here? Mr. Riemann, welcome. I think also, members, there is a prepared amendment by the association. If you'd like to pull that out, I'm sure he's going to walk us through that as well.
Good morning, Madam Chairwoman, members of the committee. I'm Jeremiah Reeman here on behalf of the county commissioners. I do have a proposed amendment for you. We remain supportive of the bill, and I'll just kind of walk through the four areas that we're looking to ask for your consideration. The first is on page 2, lines 16 through 19, and suggesting that you do adopt the amendment that is proposed on page 3 in the staff comment. I had drafted some language for that particular section, but Mr. Fuller, as always, has done a wonderful job of doing it better. So we would recommend that. Madam Chairwoman, the second place is on page 2, line 20, and that's to insert a new provision that would relate to the resolution or reassignment of all contracts to which the board or district is a party to, which this, as you may remember, came up as a conversation point in the discussion back in September. So some pretty simple language that could fit in there. Madam Chairwoman, the next proposed amendment is on page 5, line 9. And in this particular section of this proposed bill is a provision that the commissioners shall disapprove or approve by resolution the plan that had been put out for public comment. What the proposed language that I'm bringing forward to you is contemplating the fact that you may change that plan and wouldn't just adopt it in whole. So making sure it's clear that the commissioners would have the ability to revise the plan based on that public comment and then approve or disapprove of the particular plan. Looks like there may be some confusion. I want to make sure. Okay. And then, Madam Chairwoman, the last proposal is also on page 5 to delete the language at line 17 that states including the payment of, and then the language that then goes on to lines 18 and 19. It's not that this is bad language. In fact, it could stay. It's just duplicative of what's already going to be required to be in the plan. So I noticed that and bring it forward to you for your consideration. Madam Chairwoman, with that, again, we are supportive. Appreciate your considerations of these amendments, and I'd stand for any questions.
Thank you, Mr. Raymond. Thank you for the work on this bill. I know you said you'd bring some amendments and you did. We appreciate that greatly. Committee questions for the association? Seeing none, Mr. Raymond, thank you so much. Further public comment on this bill? Not a lot of interest. All right, public comment is closed. Committee, back to you. Moved by Senator Cost, seconded by Representative Washut. Committee amendments. Co-Chairman Olson would like to move the amendment as prepared by the County Commissioners Association, which does include the adoption of the staff comment on page 3. Seconded by Senator Cost. Further discussion on the motion? Seeing none, sensing you're ready for the question, all those in favor, please say aye.
Aye.
Any opposed? That motion has passed. Committee, back to you. Further discussion on the bill or further amendments? Roll call vote on the bill, please.
Senator Cooper. Senator French.
He's there.
Aye.
Senator Kolb.
Aye.
Senator Cost.
Aye.
Representative Crago. Representative Larson.
Aye.
Representative Oakley.
Aye.
Representative Provenza.
Aye.
Representative Washut.
Aye.
Representative Rodriguez Williams.
Aye.
Representative Yin. Representative Zwanitzer. Co-Chairman Olson.
Aye.
Chairman Nethercott.
Aye. All right, committee, that bill has passed. We are now on to 22 LSO 190 version 4, which is Liability for Governmental Healthcare Providers Amendment. And we will have our remarkable LSO attorney, Mr. Luke Plum, walk us through this particular bill. Over there. Welcome, Mr. Plum. Good to see you.
Thank you, Chairwoman Nethercott. Yes, I am Luke Plum of the Legislative Service Office. Yeah, I'm discussing 22 LSO 190. This one, it's very small changes in the bill. And so beginning on just page 1, it is specifically addressing 139-110 Wyoming Statute 139-110 liability for healthcare providers. The primary change is on page 2, line 3. It deletes the word negligence and inserts medical malpractice as the standard for, this is within the Wyoming Governmental Claims Act. And so that's changing the standard for this specific subsection. And then continuing on to the bottom of page 2 on line 23 onto line 1 of page 3, it's just making a conforming amendment. Volunteer health services, a healthcare provider who provides these services are still within, are still considered a public employee for applicability of the Wyoming Governmental Claims Act. And this is including Wyoming Statute 139-110, which is being changed. So that was the additional conforming amendment made there.
Thank you, Mr. Plum. Questions for Mr. Plum? Representative Craigo.
Thank you, Madam Chairman. So just I guess, as I'm reading this, if we get at the top of page 2, it says a governmental entity is liable for damages resulting from bodily injury, wrongful death, or property damage caused by medical malpractice. I'm just curious how we can have property damage caused by medical malpractice.
Your pacemaker, your new knee. Mr. Plum, if you know.
Chairwoman and Representative Craigo, I don't know if I have a specific example of when property damage could be caused by medical malpractice, but this section is specifically indicating any damages resulting from the work of a contract physician, physician assistant nurse, and those things who are providing services for state institutions. So I think, yes, maybe there could be property that is damaged, as in, yes, if there was
Maybe.
something else, some other, maybe perhaps a medical device. I don't know for sure, but I think that the change here is mostly just raise the standard away from that.
Mr. Plum, thank you. Mr. Fuller, do you have anything to add?
Yeah, Madam Chairman, Representative Craigo, certainly I think that language or property damage makes sense when the references to negligence. I think it would be maybe a question for the committee to consider whether those words should be stricken as well, given the change in this draft.
Yeah, Mr. Fuller, I agree. And I do think it's important if the committee can, with their computers, it's helpful if you look at the statute in its entirety of Wyoming Statute 139-110. So that's very helpful as we understand what this provision does. So before we try to work any amendments or understand that property damage piece, let's go ahead and read those statutes and have them ready to look at. And then also maybe just a quick reminder, either from Mr. Plum or Mr. Fuller, about the Wyoming Supreme Court case, what it did and why this bill is in front of us, just briefly.
Thank you, Chairwoman Nethercott. So that case, Wyoming State Hospital versus Romine, is the essential one here. And Mr. Fuller has provided a summary of that previously. But essentially in that decision, the Wyoming Supreme Court held that when the Wyoming State Hospital attempted to make claims that essentially Wyoming Statute 139-110 only really should apply to medical malpractice claims, the Supreme Court held that is not correct, and that they can, and also considering Wyoming Statute 139-109, which provides for negligence or for a liability for negligence of public employees working in a state hospital, that they can be read together as they are slightly different, and they held that the standard is still negligence, essentially in the Romine decision, and that these can be read together. And yes, and to the chairwoman's point, yes, Wyoming Statute 139-110 does have a higher liability standard than does the other statutes under the Wyoming Governmental Claims Act, as in Wyoming Statute 139-118 provides that there's a limit of $250,000 for a single occurrence. Or I'm sorry, for a claimant, and then any claimant, the standard rises to $500,000. Well, 110 specifically does allow for the higher liability limit of $1 million.
Thank you, Mr. Plum. Questions for Mr. Plum? All right, seeing none, appreciate you being here. Is there further public comment on this bill? Ms. Shaner, Wyoming Trial Lawyers, please come forward. Welcome. Please introduce yourself to the committee and go ahead and share with us your thoughts on the bill.
Good morning, Madam Chairman, and Mr. Co-Chairman and members of the committee. I'm Marcia Shaner. I am with the Wyoming Trial Lawyers Association, and with me also is Beth Lance, who can probably introduce herself. She's a practicing attorney here in Cheyenne, and she also helps lobby for WTLA. And we were asked to make comments on this bill this morning. Not sure that we might have been here if we weren't invited to share some thoughts. And so in preparing to talk with you today, I contacted our legislative committee and some of the attorneys who are our members, including the member whose case was the Romine case. And they prepared a short letter to you, talking to you about their thoughts about this change. We recognize it's a small change. We feel that it's not a necessary change. In this decision, the Supreme Court said that things were clear and not ambiguous, and so didn't seem to be requesting any change to this act. But I am happy to try and answer questions beyond that if I can, and Beth is here also, and I think also we might have Mark Aronowitz out in Zoom land if you want some more specific questions. Thank you.
Thank you, Ms. Shaner. Representative Zwanitzer.
Thank you, Madam Chairman. I'm not sure the committee has a letter you're referencing. Is it?
I did email every one of you, and I did email Emily. And I even think you said that you received that email, Representatives Zwanitzer. And excuse me, Madam Chairman.
Email now that came in about 3 days ago, maybe on Monday.
And Madam Co-Chairman, Marcia, is the letter you're referencing the amendment, basically? Because we have posted something that's labeled proposed amendment, but it's actually a letter. Is that it? Okay, so it's online, committee members, as
Yes, Madam Chairman.
as proposed amendment to 22 LSO 190.
And it is not a proposed amendment other than to say,
I think we just mislabeled it somehow.
right.
So. Okay.
All right, further questions for Ms. Shaner? All right, seeing none, thank you for being here.
Thank you. I always appreciate the opportunity to see all of you.
It's the #1 committee. All right. Further public comment on this bill? Fascinating, very fascinating. All right. Anyone online? No, okay. Public comment is closed. Committee, back to you. A discussion, a motion on the bill.
Move the bill.
Moved by Senator Kolb. Is there a second? Seconded by Senator Cooper. Discussion? Representative Zwanitzer.
Maybe two questions first for either Mr. Fuller or the chairman. So I'm a little confused if the Supreme Court brought this, or where in the opinion did it say there was a statutory issue that needed to be solved? I do agree.
Are you looking at the letter?
I'm not looking at the letter right now. I'm looking at the case that, from what my understanding, this bill came to us as a result of that case, that there is a statutory problem when I read it, it's more of an interpretation issue. So I guess my first question is, where did, a fix in the statute come from and why is it before us? If I could just get that information.
I do think it'd be helpful for the committee to go back and refer to Mr. Fuller's memo. I think it's very instructive. Mr. Fuller?
Yeah, Madam Chairman, Representative Zwanitzer, the previous bill draft, this and the next two are issues that the committee is considered in light of Supreme Court decisions. And the chairman have identified cases where the court has either expressly called for legislative consideration, as in the theft statute from a couple of years ago, or other cases where the court has interpreted a statute. The decision for a bill draft certainly is within the committee's purview. There have been cases in years past where the committee's taken no action, others where the committee has or will take action. So that's basically the background of kind of how this came. It was a case that the chairman identified from a list of cases that, to bring before the committee for the committee's consideration.
So I think from the legislature's perspective, the question is, did the Supreme Court interpret the statute correctly? And certainly the committee is not suggesting they did or they didn't, but is the statute written in a way that we had intended? And so the question that the case presents itself is whether or not when a medical professional commits negligence, whether or not the damage cap should be $1 million as opposed to when any other public employee commits negligence, the damage cap is 500,000, for example. And so that's the question. So why would one benefit from experiencing negligence from a just regular ordinary negligence from a medical professional? Why would there be a windfall for that event as opposed to any other public employee? So, for example, the sanitation truck driver, there's a damage cap associated with the crash that might occur from the sanitation truck driver with a damage cap limitation on that of potentially 500,000. But if the hospital employee potentially gets in a car crash, that damage cap is 1 million. Is that really what the legislature intended? Or did the legislature intend for that separate statutory provision associated with healthcare that damage cap for $1 million apply to conduct associated with medical malpractice actions, recognizing that the harm that might occur from a medical procedure or some type of professional services is likely going to be higher and therefore justifies a greater damage cap? I think that's helpful. So the Supreme Court certainly took the language in the statute, interpreted it as written, but is that what we actually intended by carving out that medical liability section of the Governmental Claims Act? And I think that's the question that the committee needs to ask itself. Not whether or not the court thinks we did something wrong. It's just that the court says, well, this is what the statute says. But I would say it's kind of a goofy result, an absurd result, when you look at the entire statutory Governmental Claims Act in total, that there would be some kind of distinguishing mark for a medical professional driving a vehicle as opposed to the sanitation truck driver. And there'd be a different result there. That doesn't make a whole lot of sense for the same type of conduct, ordinary negligence. Hope that helps. Further discussion from the committee?
Propose an amendment.
Senator Cole?
I propose on page 2, line 2, striking or property damage, which continues on to line 3.
Is there a second? seconded by Representative Oakley. Further discussion on the motion? Representative Zwanitzer.
Thank you, Madam Chairman. And this is in current statute, and so it just, I guess it worries me without me being able to fully consider what other things might be at play. I understand the word negligence to medical malpractice is the reason the bill's before us. We start amending other things in the statute, which I don't believe are related to the issue. It just causes me pause, and so I'll probably vote no against the motion. And that's my own fault. I haven't really thought about that motion coming forward and what that would mean. I think it's just too early for me to agree to it. But during session, perhaps we can have a further discussion and research what property damage might be caused in this area.
Thank you, Representative. Further discussion on the motion? Senator Cost?
Thank you, Madam Chair. I'm wondering if you have an artificial valve or a joint replacement or something, and somehow that's been messed with in a way that it's been ineffective. Would that be property? Because it's really not bodily injury. It's really not wrongful death. So would that be classified as a property? And that makes me a little nervous as to taking that out.
Great comments. Further discussion, committee? We like the silence. All right, seeing none. Sensing you're ready for the question, all those in favor of Senator Kolb's motion to strike the reference to property damage, please say aye. Say it loud. Please say aye.
Aye.
All those opposed say no.
No.
All right, that motion has failed. Committee, back to you. Further amendments? All right, sensing you're also ready for the question on the bill, roll call vote on the bill. Representative Yen has a question?
Yep, Madam Chair. So
Look alive.
thank you. I know, we're pushing it, but this section came into law about at the same time as the 109 section where we're talking about similarities. But this one has been changed about 10 different times over the years, including in 2018 and 2007 by the Judiciary Committee. So I'm curious on why, if that wasn't our intent to have it be negligence versus medical malpractice, why we never touched that until now. So I'll probably be voting no, but I think that's up to the rest of the committee.
Thank you, Representative Yen. My recollection, and Representative Larson might remember this, the provision on 3531-102 was a bill of the Joint Judiciary Committee. Really with excitement from the organization known as FGA was where that concept came from. So it might be, that might be what you're referencing when you see some legislative history there on that particular statute. Is that what you see, Representative Yen, as it relates to 3531-102?
Madam Chair, I'm actually looking on 139, 110 in the legislative history on that section.
Mr. Fuller, can you speak to that at all, the legislative history and the changes there? I don't have it in front of me.
You know, Madam Chairman, I can look more fully in a second. I do believe, though, that change in 2017 or 2018 was just a conforming change to reflect the volunteer healthcare provider. So that would be the reference. You know, in 139, 110B, you know, or who is deemed to be a public employee of the state by virtue of a contract pursuant to 3531-101 through 3531-103. That was the addition, at least in 2018. I'd have to go and look, to go back beyond that, I'd have to look.
That's my recollection as well, having done that work. That's all the amendments that have occurred as it relates to either statutory sections. And I'm getting a nod from Mr. Plum as well. So further discussion on the bill? All right, roll call vote.
Senator Cooper?
Aye.
Senator French?
Aye.
Senator Kolb?
Aye.
Senator Cost? Representative Crago? Representative Larson?
No.
Representative Oakley?
Aye.
Representative Provenza,
No.
Representative Washit,
Aye.
Representative Rodriguez Williams,
Aye.
Representative Yin,
No.
Representative Zwanitzer, Co-Chairman Olson,
Aye.
Chairman Nethercott.
Aye.
That passes.
Thank you. Committee members on the topic, which I didn't want to expand to the bill. I have heard prior to being in the legislature and my time in the legislature, the need to maybe address the caps associated with the Governmental Claims Act. Not what the bill was about. It's a much larger policy question. But just to be mindful as members of the Joint Judiciary Committee, that is a conversation that continues to hit the state. Those damage caps, I don't think have been reviewed in a significant period of time. Just a placeholder in your minds as we continue to work in the state. So with that, we will move on to 22 LSO 187, Working Draft Point 5, Parentage Proceedings Adjudication Amendments. And I think we have Anna to explain this bill. Welcome, Anna.
Thank you, Chairman Nethercott. This particular bill draft focuses on in re AAAE, where the district court dismissed a petition to adjudicate paternity after ordering genetic testing, which had already indicated that the petitioner was the father of the child. The Supreme Court did find error in that. What this bill draft essentially does is it prevents dismissal of a proceeding to adjudicate parentage filed under 14-807A, where genetic testing has proven a man to be the father of a child, unless the petition is filed later than 5 years after the birth of that child. As it stands now, 14-807A requires that proceedings to adjudicate parentage be filed within a reasonable amount of time, but no later than 5 years after the child's birth. And this bill draft would create a bright line rule where the petition can't be dismissed where a man has been found to be the father of a child unless more than 5 years have passed since the child's birth. There is a staff comment in this bill draft where we included some of the alternative language at the bottom of page 2. DFS prefers this language because they're concerned that there would be some legal interpretation issues with the proposed language as it stands now. I would probably let DFS explain that if there is someone here to speak to that. However, I'd be happy to explain that as well if you'd like me to. But that's essentially what this bill draft does, and I'd be happy to stand for any questions.
Us? Online? All right. Welcome, Ms. Arneson. It's good to see you. If you could introduce yourself to the committee and share with us your proposed DFS's proposed language and why you think that's preferred.
Great. Thank you, Madam Chairwoman. Members of the committee, my name is Christy Arneson, and I am the Senior Administrator of the Economic Security Division with the Department of Family Services. Within that division falls the Child Support Program, in which we deal with paternity. So we met with Anna and appreciated the chance to have a conversation with her with regards to the proposed language. And I think while we do understand there's an outer limit of those 5 years to bring an action to adjudicate the parentage, our concern with the proposed language is the potential for interpretation issue in which the same subsection basically says, and I think some of you know this, that if the court orders genetic testing, it's found to be the father, they must adjudicate. And then we'll be adding, if the proposed language was admitted, it would then be adding essentially the unless language. So from our perspective and in discussions with our attorneys at the AG's office, it just, our preference was just for a more, what we felt was more simplified language, which is in the staff comment, in which we thought was a little cleaner and clearer. Again, policy decision for this committee. So not to talk about the policy and or the necessity of this language, just if it was going to be added, the preference that it not cause more confusion. As such, the staff comment with the alternative language, Madam Chairwoman.
Thank you, Ms. Arneson. Questions for Ms. Arneson? Questions for Anna? All right, seeing none. Sensing you're also hungry for lunch. Committee members, is any discussion right now before we go on to additional public comment? I don't think there is any. Additional public comment? All right, seeing none, back to you, committee. Is there a motion on the bill? Moved by Representative Swanitzer, seconded by Representative Oakley. Discussion on the bill, Representative Washit.
I guess where I continue to have some issue here is the 5 years after birth as opposed to the date that an individual knows about the child's existence. If you say it's 5 years after birth, I can see the argument about not wanting to disrupt the family unit that has evolved. But at the same time, if we do have in fact a true parent who didn't know about the birth of the child for some period of time, and then those 5 years have passed, I don't know why we would impose a standard that I would think that the reasonableness language does allow for that argument that the father didn't know about the birth of the child until some period of time, but was that reasonable? And maybe it was longer than 5 years, but anyway, that's where I have a kind of hang up on this bill.
Representative Swanitzer.
So thank you, Madam Chairman. Let me take it one step further then. I would move the alternative language from lines 18 to 22. And well, let me get a second before I proceed.
Seconded by Representative Yen.
Thank you, Madam Chairman. And I do think the court has some broad discretion. I don't want it to be bounced for technicality on the 5 years after the birth. I mean, in today's day and age, the court can order these, but I would assume, a parent comes in and with those, I guess I can use proper names, 23andMe or Ancestry, and all of a sudden you realize you're related to someone, and this kid might be yours. And in this case, it was a father who very much wanted to be part of this child's life in this weird, very interesting, odd case. Yeah, I just think it's a technicality that in the 5 years, it's one less thing to have someone put up a fight against, and hopefully the judicial branch, based on the proceedings, what's best in that family or for that child, still has latitude to make those decisions without having the law bounce because it's been within 5 years.
Thank you, Representative. Discussion on the amendment, Senator Cost.
Thank you, Madam Chair. My question, and I do think that's a better move with that amendment. Is there a definition of reasonable, or where does that fall in? That makes me a little nervous. So would there be a need for us to maybe consider something with that? Because that,
The lawyers are smiling.
I know.
And
I like it when I can have them smile.
Representative Oakley, would you like to speak to reasonableness?
Members can hear or not, probably not. There we go. Yeah. Can you hear now? Okay.
I can only hear Mr. Fuller.
Okay. Hopefully I'm heard by everyone. I'll just answer the question. Reasonableness is going to depend on the facts and circumstances of the case. I think in this context, did the putative or would-be father, take necessary steps after, after the discovery that he may be the father, to file a petition or take actions to confirm that. So I think that goes to the question of reasonableness. More broadly, the language in this bill draft only codifies the holding of that INRI AAAE. This bill draft does not amend or even consider 142807A. And that's the subsection that provides the limit for when a proceeding must, by a presumed father seeking to adjudicate the parentage of a child, having a presumed father already, it must be commenced within a reasonable time after obtaining knowledge of relevant facts, but in no event later than 5 years after the child's birth. That's not in this bill draft. All this bill draft is doing is just saying that if a court has ordered genetic testing, and the results of that testing rebuttably identify a man as a father, a court then can't go back and say, you did not file this in a reasonable time. That's what this bill draft does. It does not change that 5-year upper limit or even contemplate that. You know, the wording in the bill draft itself versus a staff comment is just slightly different, but I think effectually does the same thing.
Co-Chairman Olson.
Yeah, thank you, Madam Co-Chairman. If I think I'm tracking with Attorney Fuller on, you know, the language is really only slightly different. I appreciate the comments from the committee on the reasonable time in general, but if we're going to go with this amendment, I do feel like maybe I would like to change the language slightly. It feels a little clunky, the double negative as I read it. The court shall not dismiss a proceeding to adjudicate parentage for not being commenced. Maybe something a little more, and maybe Mr. Fuller can speak to this if this makes sense, or if I'm getting too into the weeds, but maybe it could just be a little more simple and say something like the court shall not dismiss a proceeding to adjudicate parentage solely for failing to commence an action within a reasonable time. I'm getting caught up on the not. And to me, that second, I don't know if the solely has a substantial change to it, if that's necessary or not, but I think it should read for failure to commence an action within a reasonable time. And that, am I changing something too drastically, Mr. Fuller?
Committee members, I would encourage you to study the language as drafted by LSO, the original language. Just really, that might be easier. So the question is I think as well, if a petition is filed after 5 years, should the court have the ability to order genetics testing, or is that issue gone?
I think that's the reason for adopting this amendment. At least in previous, the senator and the representatives mind spoke to, you know. But I think that is the policy question.
No. So if we go back and we look at page 2, lines 4 through 10. This contemplates the court ordering genetic testing after the 5 years has passed. Is that correct, Mr. Fuller? No.
Madam Chairman, I'm not sure that idea or concept is contemplated in this bill draft. All this says is if a court has ordered genetic testing under the other statute 142702, under the provisions, that section describes how genetic testing, when that can be ordered. And then the results rebuttably identify a man as the father of a child under a different provision. You know, this language, so now I'm looking on line 7 to 10, just says that really you can't dismiss a proceeding for not being filed in a reasonable time. It would let the court still dismiss if the proceeding was initially filed after 5 years. I think the question there, though, maybe as a matter of practice, would be if someone has filed a petition to adjudicate parentage after 5 years, presumably, you know, the presumed father or someone else who has standing in that action would move for a dismissal under 142807A, because that's what that language already says, that you can't commence a proceeding to adjudicate the parentage of a child after 5 years of the child's birth.
Representative Craigo?
I think, Madam Chairman. So we're talking about a big, broad issue, but this particular bill really is very, very discreet. And we're only talking about the court's ability to dismiss the proceeding. And it's not necessarily, it's not after the 5-year period. It's
Right.
whether it's this whole reasonable time frame period after. I mean, we're creating a very specific law for one case in a very unique situation. I mean, I don't know if it's good policy, bad policy, but I think we got to narrow our mindset on what we're actually talking about, which is not necessarily after the 5-year period, because that's already prohibited by statute. You can't bring a petition after 5 years. We're talking about what happens in the interim. The reason we stuck the 5 years in there was so that it mirrored 807A.
You know, we did hear some comments from the stakeholders that potentially a bill draft wasn't necessary. But a good conversation.
Let's vote on it.
Hmm?
We got an amendment. Let's vote on it.
Co-Chairman Olson would like to vote on the amendment. All those in favor, please say aye. All those opposed? That motion has passed.
Oh,
Committee, back to you. Senator, to be on Zoom? Nope. Sensing you're ready for the question on the bill. Roll call vote on the bill.
Senator Cooper? Senator French?
no.
Senator Kolb?
No.
Senator Cost? Representative Craigo? Representative Larson?
No.
Representative Oakley? Representative Provenza?
Aye.
Representative Rodriguez Williams?
No.
Representative Washit?
No.
Representative Yin?
Aye.
Representative Zwanitzer? Co-Chairman Olson?
No.
Chairman Nethercott?
No. All right, committee members, let's get through our next bill draft, 22 LSO 186, working draft 4, sex offender termination of duty to register amendments. Mr. Fuller, you on this one?
Yeah, Madam Chairman, this bill draft is in response to the committee's consideration of Harrison versus State. That was a case where the court considered whether a statute and then subsequent changes in sex offender registration requirements would allow a registrant to count really the time he wasn't required to register for purposes of seeking relief from the registration requirement. And all this bill draft does on page 2, lines 11 and 12, and then again on page 3, lines 3 and 4, just provides that an offender may count any period of time that the offender was not required to register under this act for purposes of either meeting that 10-year threshold to seek discretionary relief or the 25-year threshold for discretionary relief, depending on the type of offense that was committed. Page 3, line 14 just makes clear this would apply to all offenders, regardless of when they're sentenced. With that, I would stand for questions.
Thank you, Mr. Fuller. Questions for Mr. Fuller? Representative Zwanitzer.
Thanks. Just I want to make sure I understand this. So the period of time when an offender is actually required is after an official guilty plea or a finding of fact in a court where they're charged. They can't count the, let's say the trial took 18 months to get there. That wouldn't be part of the, I need some help on when would an offender not be required to register and what time are those couple weeks here and there? Or is there a, it's when we change the statute?
Mr. Fuller, if you want to go back and remind the committee about the Supreme Court case and those facts that brought this issue to our attention.
Yeah, Madam Chairman, the situation, at least in that particular case, was when the Sex Offender Registration Act was first enacted in Wyoming, this particular person, Harrison, was not required to register. His crime did not trigger the registration requirement. Later, the legislature amended the Sex Offender Registration Act to include his offense. And so upon that inclusion, he was then required to begin registering as the law provided. So really, I think this scenario would only cover those individuals for whom there's been a change in the law, where they were not required to register, but later were. In terms of just a more general question, you cannot count periods where you've been confined, and you cannot count periods where you are supposed to be registered and were not. That's existing law. So this would only really be, I think, the period of time that someone was not required to register under this act because for whatever reason, that person's offense did not count, but for the legislature later changed it to make that offense count, as what happened in the case.
The last time we amended that statute, according to the memorandum that was provided to us at our last meeting, was in 2007. A quick reminder of the facts of this case of Harrison v. State. In 1994, Jeffrey Harrison was convicted of 4th-degree sexual assault. Under the Sex Offender Registration Act at the time of his conviction, Harrison was not required to register as a sex offender because the victim was older than 16. But after the legislature's amendment to the Sex Offender Act in 2007, so from 1994 when he was convicted to 2007, Harrison, we amended the act in 2007. Harrison was required to register and he began to do so in 2009. So he started registering when the law changed and he was required to do so. In 2019, 25 years after his conviction, Harrison petitioned the district court to be relieved of his duty to register. The district court initially granted his motion, but the Division of Criminal Investigation intervened and argued that Harrison had only registered for 10 years and not the 25. Harrison argued that he became eligible for relief 25 years after his conviction, regardless of the time he had registered. The district court disagreed and denied relief. So the policy question here for us to decide is for those offenders, and this would be a small fraction, I think, of people, but for those offenders who were convicted of a sex crime that then required them to register after 2007, whether or not that time from their conviction to the time that law changed should be included, assuming that all of the other statutory provisions are met, such as terms of confinement don't apply or probation and parole don't apply, they would then be eligible. So again, kind of focusing in on a narrow population here in the state of Wyoming, and that's the question for the committee to consider. Further discussion? Having some sidebar over here, Senator Cooper.
Thank you, Madam Chair. If a person moved to the state from another state and was not required to register in another state, but should be required in Wyoming, would this apply to him?
Senator Cooper, I believe it would. Mr. Fuller, do you have any comments about that?
Not 100% sure, but I think it would.
We do have Director Shannon here from the Department of Corrections. Director Shannon, it's great to see you online on Zoom. Would you like to provide some comments on this bill draft?
Yes, I would, Madam Chair. Madam Chair, Chairman Olson, committee members, my name is Deon Shannon, Director of Department of Corrections, and I also have Field Services Administrator Don Sides here with me. Madam Chair, in reference to 22 LSO 0186, I just would have a little bit of information I think would assist this, hopefully assist this committee. As you mentioned earlier, Wyoming Statute 719302 indicates the last amendment was individuals sentenced on or before January 1st, 2007. I would like to report out in two phases. One is those who are under supervision as well as those who are incarcerated. Under Field Services, which is our probation and parole, we currently only have 34 individuals that are sentenced prior to January 1st, 2007. And as a committee member, I also asked, we have 60 compact individuals who were sentenced within our states, and there's 4 individuals from those. So it's 34 total as far as Field Services, someone on probation or parole that were sentenced prior to 2007. We have no one sentenced with the original intent of the act from 1994 or sentenced on before 1985. Regarding our prisons, those who are incarcerated, it's even a smaller amount. We have 3 individuals who were incarcerated for sex offenses prior to 1985. We have 6 individuals incarcerated prior to 94 when the act took place. And currently we have 45 individuals that were sentenced prior to 2007. With that being in mind, we're looking at potentially impacting, if the bill would pass, up to 54 individuals that would have some form of sentence prior to the act when they were required for registry. Madam Chair, I stand for questions.
Director Shannon, thank you so much. I hope you heard Senator Cooper's question and curious to hear your thoughts about it, which is, what if a person convicted in another state of a sex offense moves to Wyoming? How do you think that this particular bill draft would apply to those circumstances?
Under the interstate compact rules, if an individual is convicted in another state, and my understanding, Madam Chair, is convicted of another state and moves, they fall under the statutes for the state in which we're supervising. So they would have to fall under Wyoming statute.
Now, Director Shannon, a lot of these folks who are required to register are no longer being supervised. Is that fair to say? Like, they're not under probation and parole. They're done with their sentence, but they still have this continuing obligation to register. Is that accurate?
Madam Chair, committee members, Madam Chair, that isn't quite accurate.
I'm asking.
Yeah, the individuals, we have 53 individuals that would be impacted that are currently being supervised and completed their sentences that are still required to register. And we have 54 individuals that are still incarcerated that, if this statute would change, would potentially have an impact on them.
Wonderful. Director Shannon, thank you so much. Stay close by, Director Shannon, and appreciate you getting that information for us and following up. Very helpful. I do think we have Ms. Kara Chambers from the Attorney General's Office, Division of Victim Services, to provide some information as well. Ms. Chambers, welcome.
Thank you. Good afternoon. I wanted to try to assist a couple questions that have come up, and B, make a second attempt to appeal for a request on behalf of DCI. So this always comes up on the second day of a 2-day meeting, but I have Brian in my back pocket for this. So first and foremost, to address Senator Cooper's question, if you look at 719-302 C, Roman numeral 3, it covers the circumstances of someone who enters our state and has to register within our state within 3 working days. And in fact, the statute is actually really comprehensive about all these different scenarios, even if you move counties, because you do have to register with the sheriff in the county in which you reside. I'll just be clear that the statute is really comprehensive. DCI does administer all this. They have more nuanced details, and you can see that they abandoned me. So I can just, point to the statute as quickly as I can, but it is covered. And it's rather rapid that they have within 3 working days. They have to notify the sheriff in the county in which they're going to reside. So separate from Director Shannon's concerns with interstate compact, that's a whole different ball of wax. That's when we would either house inmates from out of state or have our inmates housed elsewhere. But if I could segue then, the request that I am here to make today is to add language to part of the statute that is not actually in front of you in the bill, but is related to this case. So the bill draft that you have in front of you is addressing 719-304A Roman numeral 1 and 2. And the small addition I would like to make is to Romanet number 3, which is to add, so it's not in your bill draft, and I apologize, but I can read to you what it says. It's a very small little section.
Committee members, do you want to take a minute with the magic of the internet to look up Wyoming statute 719-304?
A3.
And Ms. Chambers has asked us to look at paragraphs A Romanet 3. All right, please proceed, Ms. Chambers.
Thank you. So I will read it for you. It says a petition filed under this subsection shall be served on the prosecuting attorney for the county in which the petition is filed we would like to insert and the division. The division is already defined in the statute as the Division of Criminal Investigation. And that is because of almost exactly this case. DCI was not aware of this petition. And so being that DCI is the executive branch agency charged in enforcing the sex offender registry, we need to know. We need to be given notice. And that is literally all we're asking. We'd also ask that it be put into the second sentence, which says, the county attorney shall not grant a petition that was not served on the prosecutor or the division. And that's the only two places. The final sentence does not require notification, but.
Mr. Fuller, do you understand that request?
I do,
All
Madam Chair.
right. Okay. Anything else, Ms. Chambers?
No, but I would stand for any questions if there's anything on that I may assist with.
Representative Craigo?
Thank you, Madam Chair. Ms. Chambers, do we also want to amend the third sentence, which says the prosecuting attorney may file a responsive pleading? What if the CA doesn't want to do it? Does the division want the ability? Because says may. Does the state want the ability to also file a responsive pleading?
Ms. Chambers?
Madam Chair, Representative Craig, no, we've decided we don't need to we just need to know what's happening. We're not going to weigh in on the merits of the petition.
Ms. Chambers, isn't it true in the case of Harrison v. State that DCI intervened and did provide a substantive response?
Madam Chair, that is correct, and that may happen, but if you would like to add it there, that's fine. I don't know that we want the obligation to always have to file a responsive pleading.
Representative Zwanitzer, it is permissive with may. Further comments, Representative Zwanitzer?
I'd like to re-go. My second question was on the or I want to make sure I heard Ms. Chambers on the second part. The court shall not grant a petition that was not served on the prosecuting attorney and DCI or.
And I apologize.
And then, Madam Chairman, I guess so if DCI or whoever is not, I guess maybe I don't understand the process. So let's say the petition served, it goes to both, then DCI would have some obligation to notify the court before they grant the petition that it was served. Does that make sense? So not only does it have to be sent to you, but then you, before the court grants the petition, the court has to make sure that it was served to DCI.
Representative Craigo?
Maybe that's very formal and in the process. I just don't know for sure.
Thank you, Madam Chair. So a return of service along with the summons would be filed with the court, so the court would know whether or not it was actually served appropriately on both the county attorney or the district attorney and the department or division.
Madam Chair, I don't think that requires an answer from me, does it?
Representative Craigo did it for you.
Thank you.
Thank you. Any further questions for Ms. Chambers? All right, seeing none. Thank you, Ms. Chambers.
Thank you.
All right. Any further public comment? Mr. Fuller? Oh, sorry. Senator Kolb, sorry, I missed you. Ms. Chambers is still here if you would like to ask her a question.
Yeah, I would, Madam Co-Chair. Yeah, I was raising my hand up and down, but it didn't work. So thanks for the opportunity. So the situation we're talking about here, and just verification of this, is it's a retroactive consequence for a statutory change that happened. Now, my question comes to this is, does any of the experts in the room feel that this person would be a danger to society if this change was to pass, where we would count the time before they were required to register? Is that going to be a consequence of danger to the public? I mean, just what is their opinion about that?
Let's go to Director Shannon, who probably has the greatest expertise associated with offenders and their risk of reoffense. Any thoughts to that, Director Shannon?
Madam Chair, Senator Kolb, our non-subjective assessments that are based would review risk assessments for that type of behavior or continued behavior. I don't believe it would have an impact as far as time going backwards. There are assessment portions of it that affect the maturity and the years of tenure, meaning how old eventually a person changes behavior through maturity. That being said, however, I'm not aware of any assessments to go back, to answer your question, to say if we go back retroactively, will that affect an outcome of behavior? So to answer your question, I'm not aware of any formalized assessment that could determine that.
Representative Washit. Thank you, Director.
Thank you.
Thank you, Madam Chair. Question for the director, if I could.
Sure.
You mentioned that we have a number of individuals who are still incarcerated whose offense predated the change in sex offender registry statute. If we make this change, will those individuals, if they were to be paroled, would they have a shorter period of time on the registry in the community if we pass this law than they would have without this law being passed?
Mr. Fuller, I'm going to turn to you.
Madam Chair, Representative Walsh, if I understand the question is, if someone is paroled early, would that somehow diminish the time they'd have to register before they could seek relief?
Madam Chair, Mr. Fuller, when we were asking about how many individuals this bill might affect, we were told that there were 64 individuals who are presently incarcerated who this language change could affect. And so I'm wondering when one of those individuals who's presently incarcerated gets paroled, when does the date of sex offender registration begin? The date that they're paroled into the community or on the date of sentence? Will they have 25 years in our community as a registered sex offender, or will their period of incarceration subsequent to the offense diminish that period of time on the registry?
Madam Chairman.
719-304.
Madam Chairman, Representative Washit, if a person is incarcerated, and this is current law,
Right.
that time does not count
Right.
for purposes of, the discretionary relief.
Representative Craigo.
Thank you, Madam Chairman. This isn't really a question for anyone other than I was just going to point out the language is still discretionary. You still leave lots of discretion to the court, which is why they have a hearing. And if there's some reason beyond those reasons stated in the statute itself, if the judges have concern, they do not have to grant the petition.
Further questions? Committee? Before we close, is there any additional public comment? Final questions for Ms. Chambers or Director Shannon? Director Shannon, final comments?
Thank you, Madam Chair. I couldn't find my raise my hand button. I apologize. Committee members, I just had one final comment and also to think about, and this goes back to Representative Washup's question. My comment regarding interstate compact also affects individuals on supervision, not just incarceration. So we do have 34 individuals that have completed their sentence that were sentenced prior to the dates indicated. So that it could affect 34 individuals that would be off, they could petition early to be off of the registry. So what I'm implying is there's 34 individuals that were sentenced prior to during the 1995 to 2007 time period, that would authorize them, if you change the language, would give them an opportunity to petition the courts to shorten their sentence or to be off the registry. Thank you, Madam Chair.
Thank you, Director Shannon. Appreciate hearing from you and that insight. Again, those numbers are helpful. All right, final questions for the director? All right, seeing none, public comment is closed. Committee, back to you. Is there a motion on the bill? Representative Yen, motion seconded by Senator Cost. Discussion on the bill. Robust. Representative Yen.
Madam Chair, I'll move an amendment to accept the DCI as requested changes.
Is there a second? Does everyone understand? Did everyone hear Representative Yen's motion, which was to adopt Ms. Chambers recommended amendment associated with providing notice to the Division of Criminal Investigation when a petition is being filed. Seconded by Senator Cost. Is there a friendly amendment to that, Representative Craigo? I think they really do want what you suggested. They just don't know it yet. It would be my suggestion that you make that a friendly, Representative Yan. So if you, Representative Craigo, do you want to explain it?
Yes, Madam Chairman, thank you. So the language I was asking about is if you go to the statute 719-304 on the last sentence where it says the prosecuting attorney may file a responsive pleading, my suggestion was we add or the division. So the prosecuting attorney or the division may file a responsive pleading.
Okay, that is, and the sponsor found that friendly. Representative Oakley, discussion on the amendment?
Yes, Madam Chair, I think, and I think what I heard from Ms. Chambers, who brought the amendment, was they didn't want that, and I think that's inappropriate or could cause the division issues because it is the county attorney that would file responsive pleadings. So if it was DCI, then it would probably have to be via the AGs, and I think I'm getting some affirmation from Ms. Chambers. I don't think that the friendly amendment is appropriate or necessary to include DCI as far as responsive pleadings.
Well, curiously, when you look at the statute, the responsive pleading is not required by the county attorney or anyone. It's a may, which is really unique when it comes to, I think, civil procedure. And you serve a legal document on the opposing party, and then they are not required to provide a response, which we know many county attorneys don't. Interestingly, in the case of Harrison, that's brought before the case today, the Attorney General's office and not the county attorney intervened and became a party to the case. So anticipating their desire to do that again, once being served with a petition, they likely probably also want the ability, but not requirement, to file a responsive pleading. I do think it is prudent to add it in on behalf of the agency. Question being called on the amendment. All those in favor say aye. Aye. All those opposed? That motion has passed. Committee back on the bill. Question being called, roll call vote on the bill.
Senator Cooper? Senator French?
No.
Senator Cole?
Aye.
Senator Cost?
Aye.
Representative Craigo? Representative Larson?
Aye.
Representative Oakley?
Aye.
Representative Provenza?
Aye.
Representative Rodriguez Williams?
Aye.
Representative Washit?
Aye.
Representative Yin?
Aye.
Representative Zwanitzer? Co-Chairman Olson?
Aye.
Chairman Nethercott?
Aye.
That passes.
All right. Committee, we are done with our formal work except for our Title 25 that we have continued over. We also have additional public comment to take. So we actually have a little bit more robust work ahead of us than one might imagine just by looking at the agenda. We know in our public comment section, many of you had heard from the county attorneys and their desire to have a discussion about compensation associated with those positions. So some questions for the committee to consider in light of the time. It's 12:23. Would you like to break for lunch, or would you like to take a short lunch, or do you want to just keep trucking? Representative Washit.
Madam Chair, I throw out a third option. Might we have lunch brought in and work through?
Discussion from the committee? What makes sense for Senator Cooper?
Lunch brought in, ma'am.
Okay,
I'm at 503 Cheyenne Drive.
like a bologna sandwich, Senator Kolb? All right. Okay, we're
Madam
gonna, yes, Representative Provenza.
Yeah, sorry, can we, if we have lunch ordered in, can we please have a break so folks can cook their lunch?
No, who cooks their lunch? Thank-
Me,
thank-
Madam Chair.
Thank you. All right, Representative Provenza, committee members, if you do want to order lunch, and we're going to have to take a break and determine what we're going to order from and wait for that food to come in and collect some money. So we'll go ahead and take a brief 15-minute lunch. Please powwow with me about your likely requests, get that facilitated, and we'll go ahead and sit here and work. We'll probably come back on about 12:40, since you can't stick to short time breaks, but the last break took 15. We'll come back at 12:40. All right.